Good morning, Your Honor.
Morning, Wayne County. How you doing today?
Doing great, sir. I'm going to have Sanchez Blunt at this camera. I'm just waiting on them to come in.
All right, great. Thank you.
No problem, sir.
Judge, I'm checking in for Mr. Wheeler. I'm willing to waive his appearance if that's okay with the court.
Okay, that's fine.
We just want to set it for an exam, the scheduled date.
I need an interpret. I'm sorry. I need a court reporter and I need a prosecutor here.
I'm on that one, Judge.
Oh, okay. All right, court reporter.
Your Honor, may I interrupt? This is the interpreter.
Yes, ma'am.
I was called for two different, what I thought were two different defendants, but I only got the information on one, and it's for Renato Nicolas Rodriguez. Is there a second person that needs interpretation?
Yes. Ramirez, Luis Ramirez.
Luis Ramirez. May I have his case number? Because I did not get that information.
He has two. One is 24056-37501. And the other is 24056-37601.
Okay, thank you so much. Good morning. I just have one more piece of information. I do have to help in another court at 9:15, but I will stay here. I will not leave until I will be listening until I'm needed.
Okay. Our court reporter just arrived, so we'll be starting shortly.
I do have one. I'm out on top of this too. And it wasn't me was being violent shit. I was like.
All right. First up, we have Mr. Dox.
Good morning, Your Honor.
Good morning, sir. You're here on Blunt?
Yes, sir.
Okay, ready on Blunt.
Carli, case number 205-639-801, people of the state of Michigan versus Sanchez Blunt. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor, and your staff. Attorney Quentin Dox, P number 79657. On behalf of my client, Mr. Sanchez Blunt. Mr. Blunt, please state your full name for the record.
You have to unmute yourself, sir.
Good morning. My name is Sanchez Earl Blunt.
What's your pleasure, Mr. Dox?
Your Honor, we want to set it for a preliminary exam.
The court will continue to plead of not guilty and set this matter for preliminary examination. How is April 8th at 10:45?
Yes, Your Honor, that'll work. Thank you.
All right, bond will be continued. Thank you. Mr. Gagnon. Mr. Gagnon, are you there?
Yes, Judge, ready.
You're here on Wheeler, correct?
Correct.
Okay, ready on Wheeler.
Carli, case number 2405-637-901, people of the state of Michigan versus Anthony Riggins. Defendant is charged in count 1, assault with intent to murder. Count 2, home invasion, first degree. Count 3, assault with a dangerous weapon. Counts 4, weapons, firearm, possession by a prohibited person. Count 5 and 6, weapons, felony, firearm. Count 7, assault with a dangerous weapon. Counts 8 and 9, weapons, felony, firearm. Count 10, domestic violence, defendant has a habitual offender, murder offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Judge. For the record, Patrick Agnew, P 69038. I appear on behalf of Mr. Wheeler. I did meet with Mr. Wheeler at the jail yesterday. I did provide him a complete discovery packet. He is aware that I otherwise would be requesting to waive his appearance this morning. Judge, as far as proceeding, we would like to continue with the exam date.
Court will waive the defendant's presence, continue to plead of not guilty, and set this matter for preliminary examination. How's April 8th at 11:15?
I can make that work.
April 8th at 11:15, bond will be continued.
Thank you, Judge.
Mr. Dozie.
Morning, Judge.
Good morning, sir. What can I do for you, man?
I have Mr. Ramirez, who is, I see he's in the custody. We have a specially assigned prosecutor, Mr. Bloomers rather.
Yeah, I haven't seen Mr. Bloomers yet. Oh, good morning.
Morning, Judge. I'm here on Renato Rodriguez. I believe he's out of custody when I'm reviewing register of actions. And
Okay, here's Mr. Bloomers now. Give me 1 second. We're ready on Ramirez. Yeah, they can come in.
Calling case number 2405-639-901, 2-4-05-637-501, people of the state of Michigan versus Ramirez. Defendant is charged in count 1, criminal sexual conduct first degree, count 2, criminal sexual conduct first degree. Defendant also has case number 2-4-05-637-601. Defendant is charged in counts 1 and 2, criminal sexual conduct first degree.
Appearances for the record, please.
Good morning, Your Honor. Jacob Bloomers on behalf of the people, P77307.
Forgive me, Judge, but Mr. Ramirez does not speak English. If we could have all of that interpreted for him, please.
Yes, Your Honor, Maria Cox, State of Michigan, qualified Spanish interpreter, IDQ 21221. Señor Ramirez,
Please raise your right hand. You swear or affirm to translate from English to Spanish and Spanish to English to the best of your ability?
I do. Señor Ramírez, llamaron a su caso, leyeron los números de los cargos 2456-3751 y 2405637601 y los cargos son de que agresión con intento de hacer daño físico grave.
And tell us your name for the record, sir.
Señor, por favor, diga su nombre en voz alta para las actas.
I can't hear you.
No podemos oírlos. Hable en voz más alta, más cerca del micrófono.
Luis Antonio Ramírez de la Cruz.
All right, what's your pleasure, counsel?
¿Cómo vamos a proceder, abogado?
Judge, we're here today for a probable cause conference.
Estamos aquí para una audiencia para determinar los hechos.
Thus far, we have received paper discovery and some of the digital discovery.
Hasta ahora hemos recibido algunos de los documentos en papel de las investigaciones y un poco de los documentos electrónicamente.
By electronic discovery, I mean I have body-worn cameras for the arrest of my client.
Quiero decir que lo que yo digo de documentos electrónicos son el video de la cámara de cuando arrestaron a mi cliente.
And I believe I have the when Ashley Sandino and her parents went to the police station.
Y creo que también tengo el video cuando Ashley Sandino y sus padres fueron al departamento de la policía.
These complainants were both taken to Kids Talk where they were interviewed.
A los dos de estas personas las llevaron y le hicieron una entrevista.
I do not have their actual interviews.
Pero no tengo el documento donde dicen qué dijeron en las entrevistas.
Therefore, I'm not prepared to schedule a preliminary exam date immediately without having had an opportunity to review this and discuss this with my client as well.
Entonces, no estoy preparado para pedir una audiencia preliminar antes del juicio hasta que haya recibido esto y haya tenido la oportunidad de discutirlo con mi cliente.
Is there a possibility they resolve it for the exam?
I can't speak to that. The people have this discovery and I'm not sure why it hasn't been turned over.
Yo no sé por qué no me lo han entregado la fiscalía, entonces no sé cuándo podría ser la próxima fecha.
Your Honor, as the court is aware, protective orders will need to be entered for both kids' talks. I will furnish those to Mr. Gozi this morning so he can sign them, and we will give those to the court for signature, and then I can send him those kids' talks.
Los documentos tienen que ser firmados por el abogado Gozi. Cuando él lo haga, se lo voy a enviar hoy. Cuando él nos los devuelva con su firma, se los puedo entregar al departamento de policía y cuando los tenga, entonces se los puedo dar al abogado Gozi.
Would the people be demanding an exam in this matter?
Yes, Judge, we will be demanding exams in both cases.
La fiscalía va a exigir que hagan exámenes preliminares en estos casos. El abogado fiscal contestó que sí, que lo van a exigir en los dos casos.
All right, that being the case, I'm inclined to set an exam date, but I need you to get that discovery to defense counsel as soon as possible.
Entonces, como han dicho eso, yo creo que voy a poner una fecha para esa examinación, pero necesito que la fiscalía le entregue esos documentos lo más pronto posible al abogado del señor Ramírez.
So I can set this matter for preliminary examination on April 10th at 10 o'clock if you're available, Mr. Goss.
I am available on that date, Judge.
Entonces
And Mr.
People are available as well, Judge.
Vamos a hacer esa examinación entonces el 10 de abril y los dos abogados contestaron que están disponibles en esa fecha.
Judge, with respect to scheduling on the 10th,
Su honoría, con respeto a poner esto para el día 10,
will the people also need an interpreter for their witnesses?
la fiscalía necesitaría un intérprete para sus testigos.
Judge, the complainants both speak English. I don't know if we'll need one for their parents or guardians at this point. I guess I would just ask the court.
Su honoría, los dos niños o niñas hablan inglés, entonces no sé si ellos van a necesitar un intérprete, pero tampoco sé si lo necesitarían sus guardianes o sus parientes.
Most likely not, Judge.
Lo más probable no.
Interpreter then. Not for the complaint.
Entonces no vamos a necesitar un intérprete para los testigos acusadores.
Am I to believe that the people will be calling just two witnesses, the complainant for each case?
Entonces la fiscalía nada más va a llamar a un testigo por cada caso.
That's my expectation, yes.
Eso es lo que yo creo, sí.
All right, so again, April 10th at 10 o'clock, we continue.
And to that, oh, I'm sorry.
Entonces, la próxima fecha es el 10 de abril a las 10 de la mañana.
And Judge, we would request a DSU report if one hasn't already been ordered.
Entonces, su honoría, vamos a pedir que nos den un reportaje DSU si aún no lo han entregado.
Okay, the court will refer the matter to pretrial services for bond recommendation.
Entonces nos vamos, la corte le va a pedir al Departamento de Seguridad de Niños a que hagan su reportaje.
And of course, if DSU or their pretrial services could be aware of the fact they will need an interpreter.
Y también que por favor le digan a ese departamento que tal vez necesitarán un intérprete.
Thank you. Have a good day.
All right, thank you, Judge.
Gracias, tengan un buen día. Gracias.
Mr. Noakes.
Good morning, Your Honor.
Morning, sir. What can I do for you?
I'm here for PCCs on Mr. Savion Riggins and Mr. Philip Bell.
Okay. Riggins first.
Sarah, can you go?
Calling case number 2405-598501 before the state of Michigan versus Savion Riggins. Defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence. Defendant has a commission with the motor vehicle adult advisory. Defendant also has case number 2405-598601. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder by strangulation, count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning. May it please this honorable court, William Noakes, P 42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. Savion Riggins. Mr. Riggins, please tell the judge your name.
My name is Savion Riggins.
Start your video, sir.
Okay.
Okay, what's your pleasure, Mr. Noakes?
Your Honor, I'm requesting an exam date, and I'd like the exam date to be the week of, it could be either the 24th or the 25th, because I'll be in a 2-week trial starting next week, and then I'll be out of town for a few days after that.
Okay. April 24th at 9 o'clock.
That'll work just fine, Your Honor. And I'm not sure I have discovery yet. If I don't, Ms. Drain, I'll let you know and you can go ahead and send it to me.
Okay, great.
If I will be continued, thank you. April
Excuse
24th.
me, Mr. Riggins, are you still on?
I'm still on.
Yeah, Your Honor, there's one issue I'd like to address before you adjourn this, and that is that Mr. Riggins is wearing a GPS tether, but he's tethered to an address that makes little sense. He'd like to be tethered to his house instead of where he is. He's staying with his minor
Relative.
children, at his relative's house. The incident occurred at his house, but the people who were involved in the incident are no longer there, and he'd like to be able to return to his house.
That's something we have to check into to make sure that complaining is no longer there. So why don't you get with Ms. Drain later on today and see what you can work out, or see if she can verify that no one else is there and that he can return back to the home that is in fact his home. And then you can send me a stipulated order.
All right, thank you, Your Honor.
Okay, thank you. Okay, we're ready on bail, Philip Bell.
All right, thank you. Goodbye.
Calling case number 2405-597901. Before the state of Michigan versus Philip Bell. Defendant is charged in count 1, domestic violence, 3rd offense.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. William Noakes, P42796, the Neighborhood Defender Service of Detroit, on behalf of Mr. Philip Bell. And if Mr. Bell isn't present on Zoom, I'd ask that you waive his appearance.
Court will waive the defendant's presence. What's your pleasure?
Requesting an exam, and if we could do it the same date, the 4/4/24, that would be fine.
April 24th at 9:30.
That should work, Your Honor.
All right, April 24th at 9:30, bond will be continued.
All right, thank you, Your Honor. Y'all have a good day now.
Thanks, you too. All right, Mr. Sullivan.
Yes, sir, I just wanted to check in on Renato Rodriguez. I'm not sure if he's yet on Zoom.
No, he's not. We have the interpreter here, though.
If I may, I have a preliminary exam with Judge Sabri, so I'll go handle that and then come back if he's not here. I'll leave it to your own discretion,
I
but
want to waive his presence.
I'd rather not schedule the exam without first speaking with him. I haven't had any contact.
Just so you know, I have a 4 defendant murder exam coming up.
What time is that?
10 o'clock.
10 o'clock. All right, I'll try to be here before 10 o'clock. Thank you.
So, Madam Interpreter, we're just waiting on the defendant. He hasn't zoomed in from the county jail as of yet.
Yes, Your Honor, I will stay on standby. I will help with the other court at 9:15, but I will not leave and I'll be listening for when I'm needed.
I appreciate you. Thank you so much. Thank you, gentlemen. Riggins, how are you? Good, sir. What can I do for you?
I'm on your,
At 10 o'clock?
yeah,
Oh,
my client's went with.
all right.
Your, excuse me, on this floor case that's pending, do they need to be separated? If they bring them over here separate.
I don't know. Somebody told me that they.
For some reason, they bring them over here, yeah, they bring them over here one at a time.
Probably so. They probably didn't tell each other.
Well, it's a lot of moving parts to this case, ain't it?
It's, for defending, they bring them over here.
Because two of them supposed to play.
Okay. Yeah, I'm saying that because I say all these officers out here, I'm like, tourniquet.
Four.
Four.
They might
Mary,
need to be separated, they bring them over here separate.
you got Marion and two Turners and Gary.
Miss Marion, like.
Marion is on a different charge separate.
When my officers out there, they showed me the four defendants, they had Marion, that's one of them too.
Yeah, he's just in the separate file.
Oh, okay.
Probably charged. Mr. Washington,
Good morning, Your Honor.
are we back to this again, sir?
Well, I apologize. It was listed on my schedule for tomorrow morning, and I don't know how that happened. So I apologize.
Thomas Stone, calling case 2456393. People of the state of Michigan versus Thomas Freeman Stone. Defendant is charged in count 1 assault with intent to do great bodily harm, less than murder or by strangulation. Count 2 domestic violence, third offense notice. Appearances for the record, please.
Morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Thomas Stone. I don't know whether we sent him a notice for tomorrow or not, but I'll contact him and ask to waive hearing.
For the waive the defendant's presence, what's your pleasure?
Judge will ask for a preliminary examination.
Court will continue to plea of not guilty and set this matter for preliminary examination on April 8th at 11:30.
Yeah, that's a good date, John.
I didn't hear you, sir.
Yeah, that's a good. What time did you say on April 8th?
11:30.
11:30. Yeah, that's a good date and time.
All right. Why don't we continue? Thank you.
All right. Thank you, Your Honor. Have a good day.
You too. One of you guys call over to the county jail and ask them where's Rodriguez. So we can get Rodriguez before camera.
All right, well. Rodriguez do?
I don't think so.
No, we didn't do Rodriguez.
No,
Ramirez.
we did Ramirez. We didn't do Rodriguez.
Yeah, Rodriguez is the only one we didn't do. The rest of the PCs we did.
Rodriguez, first one's R.
Rodriguez, yeah. He don't tell.
That's what the paper said.
Yeah, when I looked at my,
I know. The paper says with tab. And
okay. All right. Yeah, he's
they
not-
don't have. Right?
Yeah, he's not in custody.
Yeah, the paper will say tab, so I guess they
When
don't
I
have.
looked him up this morning, he was
And we go back to tab.
good.
The paper will say tab. I double check to make sure.
Even himself, when he came in, he said he wasn't in custody.
I said, I should send a paper.
Yeah.
I do. They don't have it. You should be-
So,
It'll be a case when Mr. Sullivan comes back.
He ain't showing in jail.
no, he's not in jail at all.
So Mr. Sullivan, did you know your client was on tether?
I did not know that.
Yes, I don't think I have any other choice but to issue a case.
Judge, I understand. I will see if I can't get a hold of the tether officer and maybe have Mr. Rodriguez turn himself in before he gets arrested.
All right.
Thank you.
Let's call, we're gonna call on the record. Let's call Rodriguez.
Carli, case number 2405-635-801. People of the state of Michigan versus Renato Rodriguez. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, domestic violence.
Appearances for the record, please.
Morning, Your Honor.
Morning.
Shelley Green for the people, P number 60249.
Good morning, Judge, Neighborhood Defender Service Manager Sullivan, PA 4261, here on behalf of Renato Rodriguez. Unfortunately, is not present for the probable cause.
All right. So I don't think I have any other choice but to issue a case for Mr. Rodriguez, even though I understand that he is on a tether. And there probably is some kind of language barrier that's caused him not to appear today. So you can reach out to him, get him here, we'll set aside the case.
Appreciate that, Judge. I will get on that immediately.
All right, thank you. For the issue of case, we vote bond is set new bond of $25,000 next year. Thank you, Madam Interpreter. That's all we have for you today.
Thank you, Your Honor. Have a good day.
You too. Good morning. Good morning. Okay. Somebody left their hat.
No,
It's not your hat. It's not your hat. It's not your. Look like my hat.
No.
Yeah.
Sure, fine. Talk to him.
Yeah.
Robert, they bring yours up.
Okay.
Yeah.
Good. Is yours a waiver or? Hope it's a waiver.
Should be a waiver.
Okay. Which one is your client? Which one is your client?
Card term.
Turn, card.
Counselor.
I think I'm on the third circuit. Yeah. Your question. No, what I was doing, okay.
I keep them over
Thank you.
We'll do them one at a time. You're coming in, Robert. Okay. And Mr. Gonick, your client is who?
Carli.
Okay, so 2 times. Sign it, wait. Are they related, brothers?
Half brothers. They're half I made the mistake of calling them brothers to the mom. The mom was correcting me quick.
For real?
Oh, yeah, mom got my ass. This is my son. Cartoon.
Oh my God.
Can you take a call? Can you take a call?
Okay. Gotcha. Yep.
All right.
How your, oh, yeah, okay. I don't know where it's at there.
Oh, I'll find one in there. Usually it's more than one.
I think that's it.
Okay.
Baby, let's have a good time. Yeah, baby, want to
Just when you think you're sick, yeah, when you see it all.
Mr. Turner, do you have this now?
Carli.
And Mr. Riggins has Robert.
Robert, yes.
Okay, let's have Takari.
Card.
Calling case 2455867, people of the state of Michigan versus defendant number 2, Takari Turner. Defendant is charged in count 1 assault with intent to murder, count 2 assault with intent to murder, count 3 assault with intent to murder, count 4 assault with intent to murder, count 5 assault with intent to murder, count 6 assault with intent to murder, count 7 assault with intent to murder, count 8 assault with intent to murder, count 9 assault with intent to murder, count 10 weapons, firearms, discharge, enter the building causing serious impairment. Count 15 through 24, felony firearm. Appearances for the record, please.
I'm John, I'm going to be for Mr. Carli Turner. Your Honor, may I approach?
Yes, sir. Where's my prosecutor?
Yeah,
I told her, Your Honor. Okay, thank you.
Judge, may I step out? She's coming through.
Okay. All right, people, do you have an amended information?
Yes, Your Honor.
Were they ever arraigned on the amended information?
No, Your Honor, I was moving after the exam, but if they're gonna wait, I'm gonna move now, and then they can leave the exam. Like I would move to amend count 1 and 10, and then they can leave the exam.
But my question was, were they arraigned on the charge?
No.
They're supposed to. The first time.
Can I approach you?
Okay, let's try this again. Calling case 2455867, people of the state of Michigan versus defendant number 2, Takari Turner. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2 through 9, assault with intent to murder. Count 10, weapons, firearms, discharge, enter the building, causing death. Count 15 through 24, felony firearm. Appearances for the record.
Good morning, Your Honor, Sarah Benoma on behalf of the people, P84189.
Good morning, Your Honor. Glenn Gonick, on behalf of Mr. Takari Turner, P43716.
Tell me your name for the record, sir.
Takari Turner.
All right, so the court recognizes that a couple of these charges have been amended, one of which is count 1, homicide, murder, first degree premeditated. And I believe it's count 10, weapons, firearms, discharge, enter a building, causing death. Guess we'll go ahead and arraign one of those new charges. How do you wish to proceed?
Yes, and I plan to waive reading the complaining warrant and stand you.
All right, court will enter complete not guilty. Okay. And my understanding is that the defendant is going to waive his preliminary examination, is that right?
That's correct, Your Honor. My client wishes, he was advised of his right to a preliminary examination, wishes to waive it and litigate the matter in Wayne County Circuit Court.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Can't hear you.
Oh, I'm supposed to repeat?
No, answer my
Yes.
question. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You put your hand up. So you understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. And you'll be bound over to Wayne County Third Circuit Court as you stand charged in amended complaint warrant. You understand that?
Yes.
You understand the nature and the purpose of the preliminary examination?
Yes.
You understand if you were to have one, the prosecution would have to establish that the crimes you're charged with were committed in the city of Detroit And there's probable cause to believe you commit.
Yes.
Does anyone force you to waive your right?
No.
Does anyone promise you?
No.
Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore find the defendant up to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be April 9th, 2024 at 9:00 a.m.
Thank you.
All right, Mr. Riggins, you ready?
I'm ready.
In Your Honor, that's going to be amended as well.
Sure, she would.
FIP, but it's no longer called felon in possession, and has prohibited person now. So I would just move to amend that MCL on the.
This is a different MCM?
Yes.
What's the MCM?
So for count 13, 750.224 F-A, firearms by prohibited person. For count 14, it's going to be weapons, ammunition, possession by prohibited person, and that's 750.224 F-7.
So count 13 is firearm prohibited person, and count 14 is what?
Is weapons, ammunition, possession by prohibited person. Thank you.
On case 2455867, people of the state of Michigan versus defendant number 3, Robert Lee Turner. Defendant is charged in count 12, accessory after the fact. Count 13, weapons, firearms by a prohibited person. Count 14, weapons, ammunition, possession by a prohibited person. Count 25 through, count 25 and count 26, felony firearm. Appearances for the record.
In count 11.
Oh, tampering with evidence, criminal case, punishable by more than 10 years. And the defendant has a habitual offender, fourth offense notice. Appearances for the record.
Good morning, Your Honor. Sarah Benoma on behalf of the people, P84189.
Hey, good morning, Your Honor. Good morning to your staff, and your services by Ken Riggins. P82125 on behalf of Mr. Robert Turner, who stands with me to my left. Turner, can you put your name on the record, please?
Robert Turner.
And what's your pleasure, counsel?
Your Honor, my client, I have spoken with my client about this. My client understands he has a statutory right to a preliminary examination where the state must show by a probable cause standard that he committed a crime in the city of Detroit County, Wayne. After consultation, my client is waived, saying have matter bound over to the circuit court for further proceedings.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, you'll be bound over to Wayne County Third Circuit Court as you stand charged with the complaint. You understand that?
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution will have to establish that the crime you're charged with is committed in the city of Detroit, with probable cause to believe.
Yes, sir.
Does anyone force you to waive your right?
No, sir.
Does anyone promise you?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given, and the court will therefore find the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. This arraignment on the information date and time will be April 9th, 2024, at 9:00 a.m. Thank you. Okay. Are we ready on Garrett and Mary?
Carl Jordan texted me. He should be on his way for.
Okay. So not
Mary. He should be a waiver too.
Mary is on the way.
Yeah. Yes, Carl is texting me.
All right. Versus on hold, Mr. Glenn? Yes, Your Honor. Okay. Hey, sorry, right here. Come on in, Mr. Jordan.
Good morning, Your Honor. It's good to see you.
Mr. Jordan.
Yes, Your Honor.
I understand that your client is on the way.
That's correct, Your Honor.
Have you signed the waiver form?
Just June just years. Yeah. Yeah. Yeah.
Good night.
Yes, sir.
Have a seat right there. Mary, now. Yeah.
Oh, Mr. Jordan, you're already running behind.
Oh, I'm sorry. You wanted me to sign? I was just waiting for you to.
Get your client to sign. You need to discuss the waiver with him, or you already did.
He's in custody, Your Honor.
He's
Oh, he's in the back. They told me that you had brought up yet. I'm sorry. I didn't know that he was already brought up. Thank you, Your Honor.
Your Honor, I'm going to move to consolidate his case with the other 3 defendants. And the information.
Oh, I got the wrong file.
Okay.
Your Honor, I don't have exhibits. Do you want this exhibit list?
That's fine.
Did you get it?
How many witnesses do you have?
Now that I have the waivers. Eight, I can give an offer of proof for all of them and they're gonna be quick. It'll- Oh, I don't know. So I think it's-
Let's give Mr. Jordan out there.
Stay ready for it, Jeff?
Yes.
Judge ready.
Your Honor, his mother's right out here. May I bring her right here?
Yes. Calling case 2455898. For the state of Michigan versus Herschel Lanier Marion. Defendant number 4. Defendant is charged in count 1 homicide, murder, first degree premeditated. Counts 2 through 9, assault with intent to murder. Count 10, weapons, firearms, discharge, entering the building, causing death. Count 15 through 24, felony firearm. Appearances for the record, please.
Good morning, Your Honor. Sarah Benoma on behalf of the people, P8189.
Good morning, Judge King. Attorney Carl Jordan, number 57226, appearing on behalf of Mr. Herschel Marion. Mr. Marion is present.
Tell me your name for the record, sir. Mr. Jordan.
Your Honor, I've had an opportunity to speak to Mr. Marion. I was right here for the examination. My understanding at this time that he was willing to waive that right to have the exam. He knows he will be found in the circuit.
Mr. Marion, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You understand you have a statutory right to have a preliminary examination without waiving the same. That means you won't have one. You'll be bound over to Wayne County Third Circuit Court as you stand charged with claim 1.
Yes.
You understand the nature and the purpose of the preliminary examination?
Yes.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit. It's probably possible. Is anyone forcing you to waive your right? Does anyone promise you? Are you waiving your right freely and voluntarily? Any objection from the people?
No, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court is therefore finding the defendant over to Lane County Third Circuit Court. Criminal Division for proceedings is arraigned on the information date and time of the April 9th, 2024 at 9 o'clock a.m. So, Mr. Marion, we don't think any of this is funny, do you? That nervous smile that you have? Okay. Okay, thank you, Your Honor.
Well, you're all set.
Your Honor, I'm sorry. Can we consolidate his case with the other three individuals? So when they go over to circuit court, they're all in one?
All right, we'll consolidate case number 4555898 with case number 2455867.
Thank you.
Ready, Mr. Flynn?
Yes, Your Honor.
On case 2455867, people of the state of Michigan versus defendant number 1, Nasir Lamont Ramirez. Defendant is charged in count 1 homicide, murder, first degree premeditated. Counts 2 through 9, assault with intent to murder. Count 10, weapons, firearms, discharge, enter in a building, causing death. Count 15 through 24, felony firearm. Appearances for the record, please.
Good morning, Your Honor. Sir, on behalf of the people, P8429.
William Glenn, P 36794, on behalf of Mr. Carli. Sir, state your name. Nasir Lamont Ramirez.
Date and time set for preliminary examination. Are people ready to proceed?
Yes, Your Honor.
I understand you have approximately 8 witnesses.
Yes, Your Honor.
Do you have any preliminary matters before you call witnesses?
Yes, Your Honor. The first one would be, you would ask for a mutual fee frustration order with an exception for the officer in charge of Ralph Henshaw, who sits to my right, detective.
Any objections to the OIC remand? No, yeah. There doesn't, I'm not sure who these people are in the courtroom. The young lady that's in the back. Are you a witness to this matter? Okay. It doesn't appear to be any other witnesses in the courtroom. Ladies and gentlemen, out there in YouTube land, if you are a witness or potential witness in order, you will log off at this time. Anything else, Ms.
Yes, Your Honor. People of police defense counsel notice that at the end of the exam, will be amending the charges, count 1 from AWIM to homicide first degree. And count 10, sorry, count 10 will be amended to discharge.
Okay, so why don't we? Okay, I guess we can.
And then I'll move to amend it again.
All right.
You're also, Your Honor, would move to amend People's Exhibit 1, which is the postmortem report under MCL 76611BD.
Any objections?
That wasn't even discovered, but excuse me, copy for exam purposes only.
I mean, I can check discovery because I sent it to all of them.
Admitted?
Your Honor, may I publish?
Yes.
Your Honor, reading the pertinent portions into the record. People's Exhibit 1 is entitled "The Postmortem Report from the Office of the Wayne County Medical Examiner." It certifies that Dr. Omar Reyes, Assistant Medical Examiner, performed a postmortem examination on the body of Lamara Glenn at the Wayne County Medical Examiner's Office on February 27, 2024, with an ME case number of 24-0261. In a summary and opinion portion of this document, it states, "It's my opinion that death was caused by gunshot wound to the head. The decedent was an 11-year-old black female who was conveyed to the hospital after being shot in the head while sleeping on a couch at the residence. She was found to have subarachnoid hemorrhage and multiple bullet fragments in the head. The decedent underwent wound closures. Repeat imaging showed severe anodic brain injury. She was pronounced dead on February 23rd, 2024. The manner of death is homicide." And Your Honor, last preliminary matter, we move to amend the MSP lab number MD 24-634 analysis under MCL 76611B 1D as in Delta.
Any objections?
No objections to exam purposes only.
Admitted.
And with that, Your Honor, we've already called our first witness.
Please do.
Your Honor, this time we'll call Officer Bradley Inkava.
Sir, please give your name to the court reporter. Your name is spelled.
Is it PINKAVA? Thank you.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Sir. Thank you, sir. Please have a seat. Please smile. Begin when you're ready.
Thank you, Your Honor. Can you please restate your name again for the record?
Officer Kinkava, Detroit Police, Precinct,
And how long have you been a police officer with Detroit?
about 2 years.
Were you employed this capacity on February 20th of 2024?
Yes,
Did you in fact work on that date?
yes.
Were you with a partner or by yourself?
I was with partner,
What's your partner's name?
P.O. Tyrese Henderson.
And did your duties take you at or near 6006 Pennsylvania Street?
Yes,
Is that in the city of Detroit,
yes,
County of Wayne?
yes.
Okay, what brought you to that location?
We had a shooting in progress that came out of the dispatch.
About what time did you respond to that location?
It's about 4:10.
4:10
4:12 a.m.
a.m.? When you first made that location, what if anything did you observe?
As we made the location on Pennsylvania, we observed an open door and broken glass on the residence.
Okay, did you hear anything at this time?
Not until we exited our scout units, and then we heard screaming
Where was the screaming coming from?
from indoors.
What did you do next?
After we heard the scream, we made entry to the residence.
What if anything did you observe once you're inside?
A young female lay on the couch under a blanket with, I believe, her mom standing behind her holding a rag over her.
When you say young lady, how old? Was it an adult, child?
Young child.
Okay. Did you notice any injuries on this child?
As soon as we made entry, the mother then removed what I believe is a towel, and we did see that it was GSW back there.
Okay, it's GSW?
Gunshot.
Okay. What if anything did you do next?
Next, my partners that were on scene, the primary units radioed in for dispatch for the arrival of medics, because we have to secure the location, especially in a shooting scene for their safety. And we radioed for medics to come down to see that the area was secure.
Okay. Did the medics come to the scene and transport somebody? Okay. Did someone transport the child to the hospital?
Yes, we did. We took the child and the primary unit, Officer Bond and Officer Harris transported. We followed behind and cleared traffic for them to make the way to the hospital.
Okay, thank you. No further questions, Chairman.
Cross exam.
Did you collect any evidence?
No, sir.
Nothing.
Any redirect?
No, Your Honor.
Thank you, sir. You may step down.
Yes, sir.
This one. Your Honor, this time people call Latanya Collins.
first witness name?
Bradley, and then the last name is Pinkava.
Please raise your right hand, man. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please open up the door just below me. Have a seat. Speaking to that microphone that will be to the left. Okay? Maybe when you're ready.
Thank you. Good morning. Can you please restate your name again for the record? Ms. Collins, I want to take you back to the date of February 20th of 2024. Something happened on that date that brings you in court today? Yes. Did this incident take place at 6006 Pennsylvania Street, Detroit? Yes. What is that location? The time of the incident, how many people were home in your home? Oh, 13, 14. You said about how many? It was about 14. About 14. Okay. I want to go through everyone's names that was in that home, starting with yours. Okay, with you were in the home? Yes. Okay. And then who else was in the home with you? My husband, Antonio Collins. And how old is he? About 36. Okay. Who else? My uncle, oldest than me. How old is your uncle about? 67. Okay. Who else? My daughter, Latanya Collins. Can you spell that for me, please? Latony. Okay. Who else? My son, Roger Adams. Okay. Who else? My daughter, Antoya Collins. Can you spell that? Antoya. Okay. My other daughter, Antonia Collins. Spell that name, please. Antonia. Okay. My other daughter, Tony Collins. Can you spell that name? Toei. Okay. Who else? Lamar Glenn. Who's Lamar Glenn to you? Right. Who else was in the house? Dear Hunter. Can you spell that name for me? What? I can't spell it. Okay. Can you just say it again then? Dear Hunter. Okay. Anybody else? Jasmine Clark. Can you spell the first name for me? Jasmine, J-A-M. Okay. And Diamond Thomas. Okay. I want to walk through your house with you. When you first enter into your home, what's the first room that you walk into? Living room. How many other floors are on the first floor? Is there an upstairs? When you first walk up the stairs, how many rooms are up there? 3. Now, before this incident takes place, what first catches your attention? I was asleep. Now, when you say you were sleeping, where were you sleeping at? I was in my room. Where's your room located? The first room. First front of the house. First room in front of the house, is that on the first floor or the second floor? Second floor. Okay. Is anybody else in your room with you? My husband. What's your husband's name? Antonio Collins. Okay. Is anybody else upstairs? My uncle. Who's your uncle? Oh, this would be. Okay. Is he in a different room? Yes, he's in his room. Okay. All the other children that you listed, where are they located at? Downstairs in the first room. Okay. So, what first catches your attention? I heard a loud boom. Okay. When you hear that noise, what do? I jumped up out of my sleep and I started running towards my hallway. Okay. When you get to your hallway, where do you go from there?
Down the stairs.
Okay, what do you see when you go down the stairs?
The kids right towards me.
Okay. Is anybody injured?
No borrowers.
Okay, where was she located at?
In the front room of the couch.
Where was she injured at? Did the police eventually come to your home and respond?
Yes.
Was she transported from your home?
The officer took her.
No further questions.
Cross examine.
So when you heard the loud noise, you were asleep, is that correct?
Yes.
And you didn't see anything outside? No.
You read your rest?
No, Your Honor.
Thank you, ma'am. Thanks, sir.
Yeah.
Sir, please give your name to the court reporter. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat with this box. You may begin when you're ready.
Thank you, Your Honor. Can you please restate your name again for the record?
My name is Raymond Diaz.
And where are you currently employed at?
I'm a Detroit Police Corporal at Evidence Section.
For how long have you been employed with Detroit Police?
I've been with Detroit Police Department for 24 years.
Okay, and I'm sorry, what was your title again?
I'm a Detroit Police Corporal Evidence Section.
Okay. And were you employed as an evidence tech on February 20th of 2024?
Yes, I was.
Did you in fact work on that date?
Yes, I did.
Did your duties take you at Ramirez 6006 Pennsylvania Street in Detroit?
Yes.
Can you describe that scene?
I responded to the scene of the shooting. And once I arrived at the scene, I made contact with the responding officers that were securing the scene. I received a brief synopsis, and then I proceeded to walk through the scene and identify evidence.
When you say a scene, where's the scene located at?
The scene is located in front of the residence of 6006 Pennsylvania. In the street on Pennsylvania are scattered 23 fire shell casings of various calibers.
Your Honor, may I approach?
Ma'am.
Can you people propose exhibit 4 through 14? Can you put me those photos? And then let me know if those photos look familiar.
Yes, they do.
And what are those photos of?
These are photos depicting the scene that I photographed on the night of the.
Did those fairly and accurately depict the scene on February 20th of 2024?
Yes, they do.
Your Honor, people move to admit people's 4 through 14.
Any objection?
No, Your Honor.
Admitted?
Your Honor, may I publish?
Yes, please.
Your Honor, may I share my screen?
Yes.
I'm going to walk through your observations, starting with People's Exhibit 4, which is on the screen as well and in front of you. Can you tell us what we're looking at here?
Exhibit 4 is a photograph depicting the street of Pennsylvania, which is the main road, and from left to right on the photograph is a north and south street. Scattered throughout the street, as I stated earlier, 23 fire shell cases, and they are all identified by yellow placards, number 1, 2, 23.
And Go ahead, I'm sorry.
The background of the photograph, the second house from the left is the house of 6006 Pennsylvania.
Turning to exhibit 5, which is on the screen as well. Is this another view, just a little bit closer of those shell casings?
It's a different angle facing southeast to show a different angle almost directly in front of the residence of 6006 Pennsylvania.
Looking at People's Exhibit 6, which is on the screen or on the screen.
Exhibit 6 is a photograph of the actual residence, the front of the residence, the side that faces west of 6006. On the porch, you can see one additional yellow placard on the front.
People's Exhibit 7, is that another view of the front of the house?
As I'm approaching the residence and start going up the stairs to the porch, yes.
Okay. Exhibit 8, what angle is this from?
This is from the porch, looking in a northwest direction, from the porch towards the area where the scattered casings are located.
Looking at Exhibit 9.
Again, this is there are two sections of those scattered casings, one towards the north side and one towards the south side. This particular set of casings are the ones closest to the south side or closest to the residence of 6006 Pennsylvania.
Looking at the next exhibit, were all of these shell casings placed on evidence?
Yes, they were.
Okay, this one in particular, this is People's Exhibit 10, this is flat card 12. Did you place this shell casing on evidence?
Yes, I did. This is a 45 caliber shell case.
And what was the evidence item number?
The report number is going to be 2402200031, item 32.
Okay, thank you. No further questions, Sharon. Oh, no, I'm sorry. Sorry. Exhibit 11, what are we looking at here?
Exhibit 11 is a photograph of the porch again, placard number 24. In addition to those items, you can see some yellow rods or trajectory rods identifying several suspected bullet impacts that struck the frame, the porch frame, the west wall, the door, and the windows. I placed some rods through there to identify the trajectory in which the projectiles traveled. The one in particular that was of interest, there was one that struck the lower pane of the door that shattered the glass. And I put a rod through there and a string. So I strung a specific line that went from that exit side of the door to a specific casing on the street. And on the interior, that exact same line is one continuous line that passed through the foyer and into the living room where the complaint was located.
Looking at the next exhibit, exhibit 12, what view is this?
This is a photograph depicting that exact same line from the previous photograph, looking from the porch towards the casings that are on the street, the specific casing on number 15.
People's Exhibit 13.
And this is a photograph without the use of a flash. Through the those light conditions that were visible at that time, you can clearly see the line going directly straight towards where my partner's holding the far end. That is casing 15 at that location.
And lastly, People's Exhibit 14. I think you kind of already went through this, but.
Yes, you can see the trajectory rod going in a single line with the loop line directly parallel to it. I have to show that it's one continuous straight line. It doesn't bend, it doesn't deviate.
Thank you. No further questions then.
Questions? Now, how many other bullet holes were in front of the house besides this one?
There were approximately 7 bullet holes throughout the 2 at the door, 1 at the frame of the porch, several on the wall, the west wall, north of the door, and several on the window south of the door.
All right, now, did you use any string to show where those bullets traveled inside the house?
Those didn't need to be strung. This is, the reason this particular, was of importance, I measured from the ground up. It was 27 inches inside of the residence. The impact where the, complainant was laying at is 26 inches from the ground, and that is the only impact travel from outside of the residence towards the inside in that specific line at that specific height.
Now, do you have any evidence that maybe any bullets ricocheted?
Inside of the apartment, inside of the residence, there were 2 suspected bullet impacts that struck separate walls.
And do you know where those bullets wound up going inside the living room or the house after it hit the wall?
Several exited the south wall, several were inside of the walls that we did not recover after not do damage to those walls, and 1 ricocheted off of the living room west wall, and the projectile bounced back towards the west, and it was located on the west side of the couch, which is placard number 25.
Now, the shell casings that you recovered, you said you got 1 45 caliber?
145 caliber.
And what were the calibers of the other shell casings?
There was 11 that were 40 caliber and 12 that were 9mm.
Nothing.
Okay, sir. Directing your attention to exhibit number 11. That placard number 24. What was recovered there? Was that a bullet fragment or a shell case?
That was a bullet.
That was a bullet. Okay. A fire bullet?
A fire bullet.
And how many different kinds of shell casings were recovered at the scene?
3 different calibers.
Okay, what were they?
40 caliber, 45 caliber, 9mm.
Any questions based on my question?
No, Your Honor.
No, yeah. Oh, I do have one more. Were all of the bullet strike marks that hit this house, were they all on the first floor or some on the second floor as well?
All at ground level.
All the way at ground level. Thank you, sir. You may step.
Your Honor, at this time I would move to omit People's Exhibit 15 by way of stipulation. This is a ring video from February 20th of 2024 at 1:35 a.m. at 18809 Buffalo Street, Detroit.
Any objection? For exam purposes only, admitted.
Your Honor, I move to omit People's Exhibit 21 by way of stipulation of the ring video from February 20th, 2024 at 5:31 a.m. at 18809 Buffalo Street, Detroit.
So stipulate. For exam purposes only, admitted.
Your Honor, at this time, people will call Detective Elvedin, and I'm gonna spell his last name, Addijanovvice. Oh, there we go.
Good morning, sir. Please step forward, give your name and spelling to the court. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you. Thank you, sir. Please have a seat in the witness box. You may begin when you're ready.
Can you please restate your name again for the record?
Detective Elvedin Adrianovich,
Can you spell that, please?
Addijanovvic.
And where you,
First name is Elvedin.
where are you currently employed at?
Detroit Police Department.
For how long?
Since 2014, so about 10 years.
Were you employed this capacity on February 20th of 2024?
Yes, ma'am.
Did you become involved in the investigation of the shooting of Lamar Glenn?
Yes, ma'am.
At some point in your investigation, did your duties take you to 6035 Pennsylvania and Detroit?
Yes, ma'am.
And did you obtain video from that location?
Yes, I did.
What kind of video?
Take a video, showing, white.
Not showing, I'm sorry, what kind of video? Is it a, attached to the house?
Oh, it was a indoor camera attached to the house,
Okay, what date was that from?
February 20th, about 4 a.m.
Okay, how many videos did you get from there?
From that location altogether, was 3 videos.
Okay. Your Honor, may I approach?
You may.
Right now, I'm giving you people's proposed exhibit 16. Can you watch that video, play a little portion of it until it looks, let me know if it looks familiar.
Yeah, it does look familiar too.
Okay, is that fairly accurately depict the rig camera that you recovered?
Yes, ma'am.
Okay, Your Honor, people move to omit people's exhibit 16.
No objection. Admitted.
Your Honor, may I approach? And you people's proposed exhibit 17, can you view that video and let me know? Oh, I'm sorry. And you people's proposed exhibit 18, can you view that video and let me know if that video looks familiar?
Yes, ma'am.
Is that video, what is that video?
This video from the 6035 Pennsylvania.
Okay, is it fairly accurately depict the video that you recovered from that?
Yes, ma'am.
home? Like, Your Honor, people move to omit people's exhibit 18.
No objection. Admitted.
Your Honor, may I approach?
Yes.
Same thing, I'm handing you people's proposed exhibit 20. Does that look familiar?
Yes, ma'am.
How does that look familiar?
This from the same location, 6035 Pennsylvania.
Is it fairly accurately depict the video that you recovered from that area?
Yes, ma'am.
Your Honor, people move to omit people's exhibit 20.
No objection. Admitted.
Did you also go to 6006 to recover video from that location?
Yes, ma'am.
When I say 6006, what street is that? Pennsylvania?
Pennsylvania.
What kind of video did you recover from that location?
I recovered, as well, 3 different videos.
Was it ring video?
3 videos attached to the house.
Your Honor, may I approach?
May.
I'm handing you people's proposed exhibit 17. Can you watch that video as much as you need? Do you recognize this video?
Yes, ma'am.
Does that video fairly and accurately depict the video that you obtained from 6006 Pennsylvania?
Yes, ma'am.
On what date was it recovered?
February 20th. For 4:30 p.m.
Is it timestamped on the video?
Timestamp is, timestamp is 4:05 a.m.
Okay, and that fairly and accurately depicts the video that you
Yes, ma'am.
obtained? Now, people move to omit people's exhibit 17.
Any objection? No, yeah. Admitted.
And people's proposed exhibit 19, does that video look familiar?
Yes, ma'am.
How does that video look familiar?
This video was also obtained from 6006 Pennsylvania.
Okay. Does it fairly and accurately depict the video that you recovered from that location?
Yes, ma'am.
Your Honor, people move to omit people's exhibit 19.
No objection. Admitted.
And so you went to both 6006 and 6035 Pennsylvania, is that correct?
Correct.
So you're somewhat familiar with what those houses look like?
Correct.
Your Honor, may I approach?
May.
any new people proposed exhibit 26? Does that area look familiar?
Yes, ma'am.
How does it look familiar?
This is Pennsylvania facing north,
What kind of, where's that photo from?
from Google Maps.
Okay, so it's not on the day of the incident or anything like that?
No, ma'am.
Okay, but does it fairly inaccurately depict the locations of the homes of 6006, 6035?
Yes, ma'am.
Your Honor, may I share my, or, Your Honor, people would move to admit people's exhibit 26.
Oh, good. In a minute?
Your Honor, may I share my screen again?
Yes.
On this picture, you can see it, it's here for you,
No, I can see.
but once you point it out.
Okay.
On the photo, can you show me where 6006 Pennsylvania is at?
It's right here next to the yellow house. Right here.
On the right side?
Right side, yes, ma'am.
Okay, where's 6035?
It's right here, the first house to the left.
Okay, that's on the left side? Nothing further, Your Honor.
Cross the map.
Now, other than these videos, did you collect any other evidence? No, sir. Nothing.
Can you redirect?
No, Your Honor.
Thank you, sir. You missed this.
Your Honor, at this time, people call Detective Donald Owens.
Sir, please give me an name and spelling to the court reporter. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you, sir. Please have a seat with this box next to me. Yes. Maybe again when you're ready.
Thank you. Can you please restate your name again for the record?
Donald Owen,
And where are you currently employed?
City of Detroit Police Department,
For how long?
25 years.
And what is your title?
I'm a detective and I work at the Hayward unit in the city of Detroit.
Were you employed in this capacity on February 20th of 2024?
Yes, ma'am.
Did your duties take you at or near 21003 Harper in Detroit?
I believe it's St. Clair Shores, but yes, that is the address.
And what is that location?
Mobile gas station.
And what are the major crossroads?
They call it Old 8 Mile, but it's 8 Mile in Harper, basically, right across from the 20 Mile.
Okay, is it right on the corner?
Yes,
So it's on 8 Mile and Harper?
yes. Northwest corner.
And did you obtain videos from that location?
Yes, ma'am.
Now, how many videos did you?
The system was equipped with 16 cameras, only camera 12 was out. So I got all 15 cameras except for 12 because it was inoperable at the time of the extraction.
Okay. What date were you pulling? When was it?
February 20th.
Okay. What time?
0457 to 0505 is what the detective requested.
Okay, is that AM or PM?
AM.
AM, okay. Did you have to do anything with the time?
We do a time calibration to offset time because sometimes computers, and this was a PC-based system, GeoVision, the computer could be off of real time. So what I do is I take a photo of real time to the computer time to get the offset.
When you say real time, what are you holding up?
It's a app on my phone that deals with time, and then I compare it to the time that's on the system to show if there's any differences in real time and the system time.
Was there a difference?
Yes, ma'am.
By how much?
It was fast by 3 minutes and 24 seconds.
Okay, so all the videos you obtain, if we're looking at a timestamp, we technically have to add on 3 minutes and 24 seconds to.
Approximately, yes.
Right there on that time. Gentleman approach. Any people propose exhibit 22? Playing a portion of that, can you review that video as much as you need? Let me know if that video looks familiar.
Yes, ma'am.
Okay, now, how does that video look familiar?
This is one of the, appears to be one of the videos that I recovered from that location.
Okay, is it fairly inaccurate for you to print the video that recovered on February 20th of 2024?
Yes, ma'am.
Do you people move to admit people's exhibit 22?
No objection. Admitted.
And people's proposed exhibit 23? Same thing, you can watch a portion of this as much as you need and let me know if that video looks familiar.
Big switch, ma'am, I'm sorry. It was distorting, so I tried to rewind a little bit. Sorry. Thank you. Yes, ma'am.
That video looks familiar?
Yes, ma'am.
How does that video look familiar?
It's from the same system inside the store.
Okay, and it does it fairly naturally depict the video that you obtained from that location?
Yes, ma'am.
Thank you. Karen, people move to omit people's exhibit 23.
No objection. Admitted.
From these videos, did you take still shots?
Yes, ma'am.
Man approach.
Yes.
Any people propose exhibit 24, 25? Can you review these? You
Yes.
know if those look familiar?
Yes, ma'am.
How do those look familiar?
These would be shots from the actual video. It's called still frame shots of the video to show key points in the video. Basically, that's why we do the stills.
Okay, do those fairly accurately depict the still pictures that you obtained from the videos?
Yes, ma'am.
And people move to omit people's 24 and 25?
No objection. Admitted.
And no further questions.
Cross examine.
Other than these videos and the still shots, did you collect or retrieve any other?
No, sir.
No. Can you regret?
No, Your Honor.
Thank you, sir. You may step down.
Thank you. Have a good day, sir.
You too.
No.
Your Honor, at this time, people call Deputy Lon Millhouse.
Sir, please step forward, give your name and spelling to the court reporter. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Thank you, sir. Please have a seat in the witness box next to me. You may begin when you're ready.
Can you put your report face down.
Okay.
Can you please restate your name again for the record?
Corporal Millhouse,
And where are you currently employed at?
Wayne County Sheriff's Department,
For how long?
17 years.
And what are some of your job, what is your job title?
I work in the electronic monitoring unit. Tether.
Okay. And did you become involved in the matter of People versus Nazar Garrett?
Yes,
Is that individual on tether?
yes.
And what kind of tether?
It's a GPS tracking.
Did you obtain reports for that tether?
Yes,
Did you pull a report from February 18th to February 20th of 2024?
yes.
May I approach?
Yeah.
Any people propose exhibit 27? Can you review this report? Let me know if that report looks familiar.
Yes, it does.
Okay. How does it look familiar?
This is a full report that we use for tracking individuals on Tether.
Okay. Does that report fairly and accurately depict the document you received for the tether of Nazar Garrett?
Yes.
And are people moved to omit people's exhibit 27?
Well, Your Honor, I would object this is hearsay.
I don't know what that means. This is hearsay. This is a report.
Well, if you're using this as proof of the truth of the matter, asserting where Mr. Garrett was, this report is hearsay. I don't know who's,
Sir, where is that report stored?
This report is stored in IntelliTrack services, and where Tether monitoring.
Who has access to retrieve that?
Every Tether officer and sergeant.
Is this report kept in the ordinary course of business?
Yes, it is.
Sounds like a business record exception to the code of procedure.
Now we move to omit people's exhibit 27.
Admitted over your objection. Yes, sir.
Your Honor, may I approach?
Yes.
Your Honor, may I publish?
Yes.
May I share my screen?
Yes.
Your Honor, may I approach again?
Okay.
Handing you people's exhibit 27 is a portion of this report. How many pages are in this report? Can you see it? Is it over 100 pages?
Yes, sir.
Okay, I'm gonna hand you a portion of this report, titled People's Exhibit 27, pages 1, 39, 40, 42, and 50. We'll go through them on the screen as well, and you're gonna be published the report.
Okay.
Okay, so looking at page 1, does the defendant's name appear on the report?
Yes,
Okay, where is that located at?
top left.
Okay, and is there a time frame for this report?
Yes,
What is the time frame?
February 18th, 2024, 12 a.m. to February 20th, 2024, 1:30 p.m.
Okay, I'm gonna look at page 50, I'm gonna put it on the screen. This is gonna be the last page in your packet. Okay, so looking at page 50, which is the last page in the packet, at 1:30 a.m. Where is this tether located around?
18699 Buffalo Street, Detroit, Michigan, 48224.
At 1:35 a.m. Where is this tether located at?
187
12 Buckingham Street, Detroit, Michigan, 42.
Your Honor, may I publish People's already admitted exhibit 15? People are claiming People's exhibit 15 of 18809 Buffalo Street. It's timestamped at 1:35 a.m. for 25 seconds.
If I stop to get some food, you want some? Hell yeah. All right, I'm gonna call you.
Looking at the town report, page 42, which in your packet is going to be the 4th page. At 4:05 a.m., where is the tether located around?
5964 Pennsylvania Street, Detroit, Michigan, 48213.
At 4:06 a.m., where is the tether located?
6030 Pennsylvania Street, Detroit, Michigan, 48213.
At 4:07 a.m., where is the tether located around?
6030 Pennsylvania Street, Detroit, Michigan, 48213.
At 4:08, where is the tether located around?
The same, 6030 Pennsylvania Street, Detroit, Michigan, 48213.
Your Honor, may I publish People's already admitted exhibits 16 through 20?
Yes.
Your Honor, people are claiming People's exhibit 16 of the ring video at 6035 Pennsylvania Street, timestamped at 4:04 a.m. for 26 seconds. People are next claiming People's exhibit 17, which is the ring video at 6006 Pennsylvania Street, timestamped at 4:05 a.m. Starting over the video, starting at 0. Next, people are playing People's exhibit 18, which is the ring video at 6035 Pennsylvania Street. Timestamped at 4:05 a.m. People are next playing People's exhibit 19 of the ring video at 6006 Pennsylvania Street, time stamped at 4:08 a.m. Playing this for 32 seconds, and I'll be replaying it again in slow motion. Playing the video again, but in slow motion. You are playing for 32 seconds. People are stopping the video at 17 seconds. Looking at page 40 of the title report, which is page 3, your exhibit. At 4:54 a.m., where is this tether located at? I'm sorry, 4:54.
454 is at 21003 East Haven Road, St. Lucie, 488.
What about at 4:55?
The same 21003 East Haven Road, St. Lucie, Michigan, 488.
And at 4:56?
Same 21003 East Haven Road, St. Lucie, Michigan, 488.
Your Honor, may I publish people's admitted exhibit 22?
Yes.
Here, I'm gonna start the video at 1 minute and 24 seconds. It's time stamped at 4:58 a.m. I'll be playing the video for about 2 minutes and 8 seconds. You are now stopping the video at 3 minutes and 39 seconds. Your Honor, may I publish people already admitted exhibit 24 and 25?
Yes.
May I approach?
Yes.
Your Honor, may I play people already admitted exhibit 23?
Yes.
I'm going to be starting this video at 5 minutes and 33 seconds with a timestamp on the video of 4:49 a.m. I'll play it for 20 seconds. Sorry about that, Your Honor. I'm starting at 5 minutes and 50 seconds. And I'm stopping the video at 6 minutes and 1 second. I'm restarting that. I'm having difficulty just pulling it over to get it to 5 minutes and 30 seconds. All right, starting the video at 5 minutes and 33 seconds. stopping the video at 5 minutes and 51 seconds. Looking at the tether report, page 39, which is the second page in your exhibit. At 5:30 a.m., where's the tether located around?
18699 Buffalo Street, Detroit, Michigan, 48234.
Your Honor, may I publish People's Exhibit 21?
Yes.
Explain. People's Exhibit 15 from 18809 Buffalo Street, the red camera, timestamped at 5:31 a.m. Did you physically go to the location of 18805 Buffalo Street, Detroit?
Yes.
Now, what date did you go there?
February 20th.
About around what time?
10:50.
AM? PM?
AM.
AM? Okay. Were you with a partner?
Yes.
Who's your partner?
Pikes, Corporal J. Pikes, 88 Cox. Mark Smith. Sir T. Ski. A. Massey, Officer A. Massey.
Are these individuals all from the sheriff's?
That's correct. Yes.
Okay. Was there another agency there as well?
Yes.
What agency was that?
Detroit Police Department.
Okay. Did you have contact with Ms. R. Garrett at that location?
Yes.
Do you see that individual in court today?
Yes.
Can you please point to that individual and state something they are wearing?
So right, green. I mean, how many people?
Your Honor, may the record reflect the identification of the defendant?
So noted.
And was that individual wearing a tether?
Yes.
And the report that we just went through, is that the tether that the individual is wearing?
Yes.
Nothing further, Your Honor.
Cross-examine.
Now, you just gave testimony about some locations, the first of which was at 6030 Pennsylvania Street, City, Detroit. And that was at about approximately 4:08. Now, for a house 6030 Pennsylvania, how far away or how many houses away was that from 6008 Pennsylvania?
Not sure.
Did you actually go out to 6030 Pennsylvania to see what this was?
No.
And you stated that you looked at the video at a gas station, is that correct?
No. Should I say that I looked at a camera?
A video?
Yes, yes.
At that time was about 4:54 a.m.
Yes.
Another ping?
Yes.
All right, now, that would be about 45, 46 minutes later. Now, do you have any information in your green light videos or locations where this car that you saw at the gas station was in between 4:08 a.m. and 4:54 a.m.?
I have a tether report here that shows where you're at.
The car?
No.
Okay. So you don't know if this person got out of the car and the car left? Now, you stated that you later went to a house at 18699 Buffalo Street in the city of Detroit?
That's correct.
And that was around 5:38 a.m.?
I got there around 10:11. Did you get the report? Shows in there.
All right. Now, again, from 4:54 a.m. to 4:30 a.m., you don't know where this Lincoln was.
Correct.
And you don't know who was inside of it.
Correct.
Now, you stated that you made it to this Buffalo Street where you arrested Mr. Garrett at sometime between 10:50 a.m. and 11 a.m.
Correct.
Now, Can you remove these tethers from your leg?
Yes, you can.
All right, and Mr. Garrett does not have to necessarily be the person wearing the tethers. That's right.
That's not correct.
So
If the tether is being manipulated at any point, we would receive indication that so.
So you say that a person can't take it off and another person put it on?
Technically, yes, but as soon as we get a tether alert, we show up.
But now, as far as what we saw in the video, your testimony is where the tether was, not necessarily where the individual was. You can't testify to who was wearing the tether.
We can't testify who was doing the tether. When the rest of we had the tether.
All right, and that was at 10:50 a.m., 11 a.m. on February the 20th.
Correct.
Nothing.
Can you redirect?
No, yeah.
Okay, so you said you don't know where the Lincoln was, but you do know where the defendant's tether was on February 20th at 4:08.
Yes, Your Honor.
And where was he at 4:08 on February 20th?
6030 Pennsylvania Street, Michigan 482.
Okay. And when you made contact with the defendant, you said he was still wearing the tether?
That's correct.
Did it look like it had been manipulated with or removed?
No, sir.
Any questions based on my questions?
No, Your Honor.
Thank you, sir. You missed that.
Now at this time, we'll call forensic technician Haynes. There's one more witness.
Sir, please give your name and spelling to the court reporter over there. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat with the response. Thank you, when you're ready.
Thank you. Can you please restate your name again?
My name is Teron Haynes,
And where are you currently employed?
City of Detroit, Detroit Police Department as a forensic technician.
For how long?
I've been there for over 2 years.
Were you a forensic technician on February 20th of 2024?
Yes,
Did you in fact work on that date?
yes.
You by yourself or with a partner?
I was with a partner,
What is your partner's name?
Chloe Drawing,
Can you spell the last name?
DROIN.
Did your duty take you at or near 18805 Buffalo Street in Detroit?
Yes,
What brought you to that location?
I was requested to process a search warrant.
Did you seize items from that location?
I did.
Your Honor, may I approach?
Amen.
Any people's proposed exhibit 28 through 31. Can you look at this document? Let me know if that looks familiar.
Yes, items are familiar.
How do they look?
These are the items that I collected from the scene.
Okay, do they fairly and accurately depict the items that you see from 18805 Buffalo in Detroit?
Yes.
Your Honor, people move to amend People's Exhibit 2834.
No, Judge. Admitted.
Your Honor, may I publish?
Ma'am?
And Your Honor, may I share my screen?
Yes.
All right, I want to walk through the exhibits, looking at People's Exhibit 28. What are we looking at here?
It's a black metallic sweatshirt, the front of it.
And where in the house did you recover this from?
The northeast bedroom on the first floor.
Looking at the next exhibit, People's Exhibit 29. What is this?
That is the back of the same sweatshirt, the previously mentioned sweatshirt.
People's Exhibit 30. What are we looking at here? Where is this located at in the house?
So that'd be on the second floor. That is in the opening of an attic, and that's that firearm, lock firearm.
Looking at People's Exhibit 31. Where is this firearm from?
That is the firearm that was just shown in the attic.
Okay. Looking at People's Exhibit 32. Is this the same firearm?
Yes, it is.
Looking at People's Exhibit 33. Is this the same firearm?
It is, yes.
And then lastly, looking at People's Exhibit 34. What are we looking at here?
That'd be the magazine that was recovered from the firearm.
This firearm, was this placed on evidence?
The firearm, yes, it was recovered.
What was it? Yeah, okay. What was the evidence tag?
10.
Cross-examine.
When you executed the search warrant, how many people were in the house?
How many people were in the house? 3 were in the house. 3.
All right, now, this gun by the attic, exactly where is that located in the house? How do you get to it?
So once you enter through the front door, you just head straight the west through the kitchen, up the stairs onto the second floor. And it's in the ground level, so you get the second upper floor.
Was that by a bedroom?
There is a bedroom, yes.
All right, was there any items recovered from your search warrant in the bedroom?
Yes.
And what was that you did?
The items recovered from the bedroom on the second floor were, it was loose live ammunition from a drawer along the wall in the bedroom.
Did those go to this gun?
I cannot say.
Now, was this like a doorway that you would go to, or was this a top that you would lift to get into that? How do you get into that? Doorway?
Yeah, it's an opening on the ceiling, and you can get through to it by just a step stool or ladder, small ladder.
All right, did you see a step stool or a ladder by this opening?
No, well, that was one on the second floor. Yes, we used that to grab the firearm.
All right, can you take a picture of that?
Did I take a picture of the step stool?
Yeah.
I can't say it's not in these photos that are presented from me.
Right. Now, was this area in the house restricted to just any particular bedroom or any particular section of the house, or did anyone in the house have access to this attic open?
You could have access to it. Everyone had access to it. Oh.
Nothing else.
You redirect?
No, Your Honor.
Thank you, sir. You may step in. Oh, I do have one question. What kind of gun is that?
That's a Glock. It's a Glock handgun.
A Glock. What kind of ammunition does that gun fire? Or do you know?
The magazine was empty, so I can say what magazine expired, but I'm not sure off the top of my head. I'd have to refer back to my report.
Thank you. Any questions based on my question?
No, Your Honor.
Oh, yeah. Thank you, sir. Yes, sir.
What was my subpoena?
Sorry.
My release from my subpoena.
Yes, sir.
Your Honor, my last witness is going to be Officer in Charge Detective Deval Crenshaw.
Swear I'll try to tell the truth, the whole truth, and nothing but the truth, so help me God. I do. Thank you, sir. Please have a seat for the response. May proceed with the prayer.
Thank you. Can you please restate your name again for the record?
Deval Crenshaw,
Where are you currently employed at?
City of Detroit, Detroit Police Department.
For how long?
9 years.
And what was your role? Did you become involved in the shooting of Lamar Glenn?
Yes, ma'am.
What was your role in that?
I was the officer in charge.
And did you request lab testing from MSP for evidence in this case?
Yes, I did.
And Your Honor, may I publish people's already admitted it was exhibit 3?
Yes.
Your Honor, may I approach the witness?
May.
Any people's exhibit 3? Does that document look familiar?
Yes, ma'am.
How does that look familiar?
This is the Michigan State Police lab report.
Okay. And Your Honor, may I approach?
May.
Any people's exhibit 10 and people's exhibit 32? Can you look at both of those pictures?
Okay.
Did you submit the lab request from MSP for those 2 items?
Yes.
Is that on the report that you have, the exhibit 3?
Yes.
Okay, so item starting with people's exhibit 10. It's showing a flat cart 12. Is that a shell casing?
Yes, ma'am.
Okay, where was that shell casing at?
That shell case was recovered from the curtilage of 600.
Okay. On the MSP report, where is that located at? What page?
So on page 2, item 15, it says 145 auto caliber Winchester fire cartridge case.
Okay. When it says agency item 32, what is that?
That would be the Detroit Police Department item. Our evidence item number was 32.
Okay. When it says 12, what's this unsealed envelope 12, what number is that?
It will be 12 as in placard 12. They evidence check mark the envelopes as coincide with the placard, so they don't get confused.
Okay. Looking at people's exhibit 32, is that item, where is that item found on this report?
Yep, so on the same page, item number 6, 145 auto caliber Glock 36 model semi-automatic pistol serial number.
Can you read the serial number?
Yes, GRC 889.
And when it says agency item, what is that?
That's the Detroit Police Department evidence check.
Okay. Now, did you receive results of these 2 items?
Yes, ma'am.
Where are those results listed at on this document?
So on the 3rd page, the results will be listed under the first one where it says results of physical microscopic examination.
Okay. Walk me through that. What does it say? We have items 1 through 5. Is that relevant?
No.
Okay.
No, not to, no.
And then it says and 15, what's that?
Correct. So 15 would be the shell casing.
Okay. And then can you read what it says after that? So read after and 15 and then just read that.
So and 15 are identified as being fired from item number 6. Pistol.
Okay.
So completely it says N15 45 auto fire cartridge case are identified as being fired from item 6 pistol.
Okay. No further questions.
Now, as far as any lab tests, did you get any DNA or fingerprints as to who handled this gun?
No, sir, not this time.
Nothing. You hear me, right?
No, Your Honor.
Thank you, sir. You may start.
Thank you.
No further witnesses, Your Honor.
Any witnesses for the defendant? No, yeah. People?
Your Honor, we first heard from the responding officer that goes to 6006 Pennsylvania Street for a shooting around 4 in the morning, about 4:15, I believe you said. They transport Lamar Glenn to the Children's Hospital for a gunshot wound to the head. We next hear from Ms. Collins, who's inside of the home. And she lists that the individuals inside of the home are Lamar Glenn, which is count 1. We have Antonio Collins, which is count 2. Antonia, with an A, count 2. Antonio Collins, which is count 3. De'Ara Hunter, which is count 4. Latanya Collins, count 5. Antoya Collins, count 6. Tony Collins, count 7. Otis McGee, count 8. And Latanja Collins, which is count 9. So we have all these individuals in a home. We next hear from the evidence tech who recovers plat card number 12. That's the shell casing that we were just discussing from the MSP lab. That's at the scene outside of the house. That's People's Exhibit 10. We hear from Deputy Millhouse. We track the defendant. We first start at Buffalo Street. We see 4 individuals leave that house on Buffalo Street, enter a vehicle, which is a white SUV. That's People's Exhibit 15. And then we have Exhibit 16 through 20. Basically what those are doing is going back from 6035 the house and then 6006 that house, these ring cameras. So People's Exhibit 16, we see this white SUV turn onto the street and drive and basically slow roll by 6006. We see the same thing in People's Exhibit 17. We have this white SUV style slow rolling by 6006. We then have Exhibit 18, which then shows that same vehicle coming back down the street, and he turns off of Pennsylvania. What's important is in the video, you can see a brake light. So the vehicle turns off of Pennsylvania, you can see a brake light light up. Now the next one we have is Exhibit 19. We can see in the video muzzle flashes coming from 3 different locations. That's why I played in slow motion. I can play it again. You can see muzzle flashes from 3 different locations on that video. And we've got one person in the car with their foot on the brake. Because we know that because the brake lights lit up. That's Exhibit 20. When we see, which I didn't really point it out, but I can point it out and show it. Because Exhibit 20, you see shadows running back to the vehicle. It looks like 2, but if you really look and I can point it out, it can be 3 individuals running back to that vehicle. Again, the brake light on that vehicle is still lit up. Someone's sitting in that car with their foot on the brake, waiting for the 3 shooters to run back to the car. We next have gas station video that we know Sar Harris at the gas station. The last video we had, he's back at Buffalo Street with another individual, and they about 5 them. We know for Deputy Millhouse, he goes to that location at Buffalo Street. He observes Ms. Garrett. He still has the tether on. It hasn't been tampered. He has not received a report that it's been tampered, and nothing's showing that he took off his tether. We then have the evidence tech that goes to the Buffalo location, recovers the Glock from the attic. We know from the MSP lab that this Glock is a match to the shell casing at the scene. So one of the firearms at the scene with the shell casing is located at Buffalo, where the defendant is then arrested. We track Ms. Garrett to the exact location of the shooting. 4 individuals leave Buffalo. We then see 3 individuals and their muzzle shots flashing and 1 individual in the car. Whether Ms. Garrett's in the car or whether he's shooting through aiding and abetting, it's 1st-degree murder. Count 1 was originally AWIN. I'm asking for it to be amended to 1st degree. Because since then, Lamar Glenn has passed away. That's MCL 750.316-A. Count 10 to be amended to discharge into a building causing death, which is MCL 750.234B5. And I'm asking for the courts to amend the charges and then bound over all the other charges, which is the company selling firearms.
I do have one question for you, though. It relates as to the assault with intent to murder. Latanja Collins and Antonio Collins, I believe that's the husband and wife.
Correct.
They, according to Latanja Collins, they were upstairs.
Correct.
And according to your officer, the evidence that you testified about the shots being fired into the house, they were all fired at the lower portion of the house, that first floor. So how is Latanja and Antonio Collins in the line of fire? They were downstairs.
All the shooters don't know where these individuals are at the house or anything like that. They don't even know if there's people on the first floor, the second floor, they're just shooting. Any of those bullets could have ricocheted, anything. So does it matter if they know where they're at in the house?
You have to have specific intent.
To harm.
Specific intent to murder.
Correct. They went to a home at 4:30, around 4:15 in the morning, when you know individuals are sleeping. It's a 2-story house. You can assume there's bedrooms on both floors. And they shot.
Yeah, I would object to the bind over. Although we have a white Lincoln SUV here in the car, we see different individuals coming and going from the car. We don't know how many people in total are in the car. We have to assume.
But we do know your client went to the car, was on Buffalo Street, and ended up on Pennsylvania Street. We do know that, right? By way of the tether.
That's what the tether report says.
Right, and your client was affixed or attached to the tether, right?
I can't say all that. I'm just saying his
tether
tether.
Is that what the evidence shows?
Well, that's what the tether report says. If you ask me to stipulate that my client.
No, I'm not asking you to stipulate anything. You heard the evidence like I did. You heard the testimony like me.
Yes, sir.
The Wayne County Sheriff deputy testified that he went there and arrested your client. Your client still had on the tether. It didn't appear to be tampered with.
That's what he testified.
Right, and that tether can be tracked from going from one location to the target location on Pennsylvania, right?
The street 6030
At the time that the shooting occurred, right?
Yes, John.
Okay.
We have to assume that there were just 4 people in the car. You don't know if Mr. Garrett was in the back seat sleeping or anything. Now, when we look at the videos, we cannot tell who is who. When you look at the gas station videos, we cannot tell who is who. Just because you have a tether report doesn't mean that Mr. Garrett shot or killed anyone. So I would object to the bind over. There's no direct evidence that my client took part in this shooting.
I appreciate you, Mr. Bennett. With all due respect, April Tuesday was yesterday, not today. We have the defendant who was, for lack of a better term, dumb enough to be wearing a tether at the time that he did it. Allegedly. Leaves the address on Buffalo, and at the exact same time that this white SUV, and you see him getting in the SUV as well. At the exact same time that the shooting happens on Pennsylvania, the defendant's tether shows that he's there as well. Now, there's nothing to show that that tether came off at any point in time, period, whatsoever. We know the defendant has a tether on and is at that location when the shooting happens. In addition to that, we have one of the weapons that was used in this shooting recovered at this house on Buffalo as well, where we have the defendant who was arrested at that location, who's seen at that location. Gun is recovered, clips are recovered, he's recovered. This was a house full of children, a house full of people. You have an 11-year-old girl who lost her life over this nonsense. Ridiculous. Type of stuff that gives our city a bad name. Shooting into an occupied house at 4 o'clock in the morning. Incredibly reckless, incredibly dangerous. incredibly astute. This court is satisfied that people have met their burden of probable cause as it relates to all the charges contained in the complaint, including the assault with intent to murder as it relates to Latanya Collins and Antonio Collins. There may be somewhat of a question, but that question remains a question of fact. And I say that because I liken it to shooting into a crowd, which we normally charge second-degree murder. But shooting into an occupied house at 4 o'clock in the morning, that many shots as well. Whether he was, like the prosecuting attorney said, whether he was the driver of the vehicle, who was waiting, aiding and abetting and assisting the others who were firing that shot, or if he was the one out there firing the shot himself, they're one and the same. There's any amount of aid and encouragement one gives another in the commission of the crime just as guilty as if they did in fact pull the trigger. So the court will bind the defendant over to Wayne County Third Circuit Court, Criminal Division for further proceedings. His arraignment on the information date and time will be April 9th, 2024 at 9 o'clock a.m. He will be remanded to the custody of the Wayne County Sheriff. Thank you.
Thank you. Dr. will take back the exhibits.
Yes.
I want to big.
Gabriel Moore.
Yes.
Did you get that check, Mr. Moore?
It's one of the issues we want to address with the court.
I'm sorry?
It's one of the issues we want to address with the court.
On the case 2456061, people of state of Michigan versus Gabriel Joshua Moore. Charged with count 1 homicide, murder, first degree premeditated. Count 2 assault, pregnant individual, intentionally causing miscarriage, steals her. Count 3 weapons, firearm, possession by felon. Count 4 felony firearm. Count 5 felony firearm. Then has a picture and report defense notice.
Good afternoon, Your Honor. Mark Fedoruk for the people, 376-177.
Good afternoon, Your Honor. James King, P number 85229, going with my co-counsel.
Good afternoon, Your Honor. Paulina Montez, case 7105, representing Mr. Gabriel Moore.
Mr. Moore is present, and to our left, Mr. Moore.
There's a date time set for the examination. Are you ready to proceed?
We are, Your Honor.
How many witnesses for you?
I anticipate 5 witnesses.
And do you have any preliminary matters before we call it?
No, Your Honor.
Okay.
We do.
Okay, go ahead, Mr. King.
So, Your Honor, there's a few matters I'm going to address with the court. One being a discovery issue. Defense counsel and opposing counsel spoke at length last week with regards to outstanding discovery. It was my understanding at that time that discovery was going to be sent over to defense counsel in time for us to use it for our investigations and the purpose of these cross-examinations. To exercise our client's rights to a cross-examination opportunity. Last night, I was notified by my assistant at probably 8 o'clock at night that we had just received up to 14 hours of discovery. Some video footage, and also a second statement, something from Mr. Moore that's alleged to have also gone on for about 3 hours. Obviously,
You didn't know about that?
Again, I requested everything. I was told we could get
My question to you is, you didn't know about that? I made a statement.
A second statement? No. So I wasn't aware of that. And again, I wasn't aware of this discovery that we didn't receive, didn't come in until last night. It just got uploaded, so obviously I didn't have the opportunity to review it in order to prepare for today's hearing. Moreover, there was the court of finding in this case that the medical examiner based her opinion primarily on the opinions of the investigating officers in this case.
In the what?
On the opinion of the investigating officers in this case. The medical examiner made 3 separate opinions in regards to the manner of death. First was suicide, second was inconclusive, the third being homicide. In each one of those addendums, there was references to communications between DPD and the medical examiner, specifically electronic communication. Upon review, over the weekend and yesterday, I realized we didn't have that. And that's clearly a basis for the medical examiner's opinion, seeing as how the cause of death did not change. Only the manner of death changed over and over again. And so when I make references to us not having those communications to opposing counsel, it was mentioned that we could receive the emails after today's hearing. I understand this economy. I'm not trying to waste this time. I understand that we have this time set for hearing today, but I believe that in order for us to be able to effectively cross-examine the expert as to her opinion and why her opinion is what it is today, that we would need those communications so that we can know what it is she based her opinions on.
Do we have the medical examiner here to testify?
We do, Your Honor.
All right, why can't you ask her those questions?
Because then I'm just stuck with her response. I don't have the emails to cross-examine.
But you also constrain her to that testimony that she gives.
I don't disagree, Your Honor. I guess my thing is there's science, and then there's facts, and then there's opinions. All of those are going to be an issue for the court to determine probable cause.
Hold on a second. Why weren't you able to give me emails now?
So I don't have that information. All I've learned from talking to Dr. Kroon, the medical examiner, is that there was correspondence with Detective Shakur, and
okay, so none of that really answers my question because
I don't have it. That's my answer.
But doesn't your officer in charge have it? It should be in his set of items.
So I can ask Detective Shakur if he's.
Why wasn't that done?
Your Honor, these are things that I discovered yesterday. So
you've had all today to
the ME's report. The ME's report, her first addendum, does indicate that there was communication between her and Detective Shakur. Defense can ask her about that when she's on the stand, and she can testify to what those communications.
I said that. You don't have to repeat either. My question is, why can't you get me those emails like now? Particularly since your officer in charge is here, they should be as simple as him going into his email account and pulling up his sent items, communications that he had with the medical examiner.
I can ask him to do that. And if it's going to delay, I don't know if they're going to get delayed or fine. I can ask him.
I'm still getting this done. Literally, I was across the street having a motions hearing, and as I'm sitting there, my email is going off.
The bigger problem, though, is that counsel is correct that his client has a Sixth Amendment right to not only assistance of counsel, but effective assistance of counsel. And if he's just getting discovery, hours and hours of discovery that exceeds the period of time that he has to prepare for, he can't be effective.
You know, for the record, the defendant doesn't have a constitutional right to preliminary exam. So as far as the right to cross-examination and whatnot,
I said he has a constitutional right to effective assistance of counsel at every critical stage of proceedings. And this is a critical stage of proceedings.
And I wouldn't agree that items that we don't have in custody that we need to request, that he needs all of that. Now, what I would tell the court is just to set the record straight. All the discovery was provided to counsel last week. And counsel noted like a second interview that the defendant had. That was actually an interview where he only exercised Miranda rights, didn't give a statement. At any rate, that was provided with the original discovery. So counsel had.
So there's no statement that he has to go to. He just exercised his Miranda rights.
No, and counsel had. As far as the cell phone information, that was also provided to defense last week. Now, I received, just yesterday, I received some additional download information. What we already had given counsel was PDF information from the defendant's phone that addressed the things that I was going to get into with Detective Shakur, his location information from the phone, and the texting that he had.
So the voluminous information that he received, he already had, and you just added on to it.
It was additional information that I got. Yes, additional information I got. Just yes. So I got to pass everything on.
Mr. King, that it's a little misleading to say that you were bombarded with all this information. You've already had the majority of the information.
What's misleading, Your Honor, is I'm not sure counsel has seen the email.
Not what?
I'm not sure counsel has seen the email that was sent to us with the discovery, because when I went through the line, what we do in my office is when we receive discovery, even if we don't have the opportunity to review it, we take note of what it is and what it entails. The majority of what was sent to us appears to be video footage of the complainant's home, which is almost of the Airbnb that the complainant was residing in at the time of this incident. And again, it appears to be over 10 hours long. In addition, had
you received any of that before yesterday?
I don't believe so. And what
it was sent, Your Honor. What I sent yesterday was everything I already sent plus 6 files that have the additional cell phone information. Now, I also sent in an email directly to Mr. King and his colleague associate. I explained in that email that it was only the 6 recently uploaded files that were new.
How long are those?
They're not video. It's all it is downloaded cell phone.
Yeah, of course we can go.
Sorry?
Yeah, of course we can go.
Can you step to the microphone, sir?
Yes, my apologies. I asked for the course we can go.
Okay.
Courtroom closed. So, I have 1, 2, 3, 4, 5, 6, 7 videos. 1 video from that's labeled second interview. Whatever the cell phone information is that the opposing counsel is representing, not designed by the script.
So he already told you the second interview is not even an interview.
So the reason why I am reluctant to believe that is because my understanding is that after the Miranda rights were invoked, that there was still communication between Mr. Moore and the officers after 2 hours. Because he wanted to speak, because he didn't want to be received. I don't have, and I'm showing, I can show opposing counsel on my screen right now, I don't have the sales out stuff. And I also believe that there's like, they have the owner of the Airbnb and the officer who found the body, who I think they can call today, and we can get the cross-examination done. But to the extent that I have to cross at least one expert and one officer doing an expert's job, I think that it's important for us to have this information in time to digest it. And so literally in the medical examiners.
Well, when did you discover you didn't have this stuff?
When, after I went through each and every one of yesterday and today, and I realized I didn't have this communications with the addendum. I kept asking myself, excuse me, why the changes? And upon a more significant review, the medical examiner literally says that if DPD finds something that's concrete with regards to the manner of death, then there could be an additional addendum. Then I read again where it says that there's been communications with regards to the first addendum. And I'm like, well, I don't have that. And I've been asking for everything from the experts.
Officer, what's your name, sir?
Officer Shakur.
Officer Shakur, are you able to retrieve those email messages you sent to the medical examiner?
He sent them to me, Your Honor, and I will pass them on to defense counsel via cell phone. Yeah. Your Honor, with response in response to counsel's other claim as far as not getting whatever he's alleging the people hadn't given him prior to yesterday. I can go through evidence.com, I can pull up the audit log, and I can show when there was actually 2 evidence.com files of percentage counsel. I can show them what was sent and when. My easy explanation today is I know that he was given all those items before, because the only thing I added today was the 6. Sorry, it was yesterday. The only thing I added yesterday to that discovery file was those 6 cell phone extraction files. That was it. So I can tell the court that it was received before. Now, I mean, whether
Mr. King, have you opened up these items and looked at them?
Looking at it right now, I just saw it. All I see are videos and the videos of the home and the interview, something that they second.
And you maintain that you didn't receive those videos last week?
No, I think the 7 new ones he's referring to, 7 different attachments he's referring to.
No, I'm not talking about that. He said that was an addendum to the stuff he had already sent you last week. You said you don't even have that, but the stuff that you do have, videos, did you receive those videos last week?
I submit to the court that I would have to take him at his word, because I haven't had the opportunity. This is the problem with late discovery. Like, I haven't had the opportunity.
Well, it's a problem with late discovery, but it's also a problem with late preparation.
I haven't slept. I prepared for today in a way that I haven't in a very long time, which is why I'm upset when I find out that there's more stuff that we haven't received. Because when I called opposing counsel last week.
But if you had saw this last week, you would be able to answer my question that yes, I did receive this, or no, I didn't receive these videos last week. It sounds like you didn't start looking at this stuff until last night, and then you discovered that you don't have everything that you need.
Oh, sorry. These are labeled Channel 1, 2022, 1101, and there's like 8 that are labeled 1102. The sequence of numbers don't tell me at first glance whether or not I received said information. I literally have to go through these click through and see the time.
So let me ask you this, what are you asking for today?
Today, I'm asking the court to allow the defense counsel for additional time to cross-examine the medical examiner and the detective advance in the law with regards to and give us leave to address the videos or the additional stuff.
What do you mean leave?
If we, like at the conclusion of a cross-examination of the witness at cross today, if I see something I think is new, I ask the court to allow me to reopen my cross.
So I would be inclined to not hold in part, but to do everything at one time.
Your Honor, can I just make a record of something? I never received a call from Mr. King last year. I called Mr. King, and I wanted to straighten all this out as far as discovery. And I indicated to Mr. King, hey, look, there's some stuff we still need to get you. We're going to get you that by the end of the week. I was going on vacation, so I wanted to make sure that he was aware of it, and that our assistant who was handling getting the discovery was aware of it. It got sent out on Thursday while I was out, and then again, some additional items came in. I tried to get a hold of Mr. King this morning just to make sure, iron out any issues. I didn't receive a call back. So the communication was there on our end, to make sure that Mr. King knew what we still needed to get him and what we got him. Never request for the emails, whatnot. I just sent those to him, by the way. And so again, I made all the efforts that I could as far as getting Mr. King everything ready to proceed. So I just want to make that.
And just to set the record clear, I stand corrected. Ms. Montez emailed the opposing counsel because we realized we were missing things. And he did call me, and we spoke about things that are outstanding. And we spoke at length about why I needed all the things with regards to experts. But all I'm trying to do is make sure that we are able to address these expert opinions before this court effectively. So I'm not trying to delay any other witnesses testifying. I have no problem completing our cross-examination with regards to the other witnesses that were referenced by the prosecution. I just think that in order for us to be able to exercise Mr. Moore's rights to the preliminary examination, that I need to review these things and to just give me stuff the night on the eve of the preliminary exam, the morning of, and then while we're here, I think it hamstrings the defense.
He says the only thing that he's giving you that's new are these uploads of phone records or something like that.
I don't have it, so I understand he's saying he sent them to me. When I look at what I have,
says all the other stuff you've already had.
Well, not the emails between that I was just sent.
Right. Well, the discovery is ongoing, and if you just requested that, when did you make that request?
When I realized that I hadn't sent everything
that doesn't tell me, because I don't know when you realized.
Last week I made a request that I asked for everything. It almost got kind of contentious.
Specific. When did you ask for these emails?
During the conversation. It wasn't emails. Let me make it clear. I asked for everything that the expert based their opinions on. Because the communication between opposing counsel and I broke down. We were talking about the experts testifying by Zoom, if I could have the opportunity to have the discovery and to interview. And then things went awry. So I was like, well, I'm going to need everything that they base their opinions on for next week's hearing, and we can just address it with the judge next week. So that, to me, although I didn't specify emails, I'm asking for things that an expert's going to get up there and testify on. I'm asking for everything.
Like I said, I'm not interested in doing this in part. Do you have civilian witnesses that you call?
I have one civilian witness. I do have the assistant ME who she is here present because in our conversation, I was never able to get an agreement on doing tests. I mean, if we have to come back, I would ask the court to order doing testimony for my medical examiner. But I would, at the very least, like to call her today. I'd like to call our civilian witness, Mr. Stanton, who's also a detective.
Okay, I'm all in favor of the civilian witness being called. The medical examiner, however, Mr. King is indicating that you can't effectively cross-examine her, because this sounds like a very important issue in the case as to what she based her findings on. And please, how many emails have you just put?
Levi.
Mr. King, that's not something you can look at right now?
No, to me, I think I can do anything.
Excuse me?
I said, to me, that's a trick question. I think I can do anything. Can I do it directly?
You don't have to type to the microphone, sir. I'm the right stand so far back.
My apologies. I don't, I think I have the ability to look at it and come up with questions, but I don't think I would be doing my due diligence, you know, if I was not spending time.
Four email messages?
Yes. I don't know the context.
I want you to take a look at it.
This is complete. Can I recite it to the court?
I'm sorry?
I don't think this is complete. Can I recite it to the court?
Go ahead.
I see from the meeting, Roger, that we will be first thing in the morning. I work on in the afternoon. We need as soon as possible. We need as soon as you return. I understand you have a lot to catch up on. I appreciate you taking the time out of your day to review the investigative report. Then there's a report that I can't open. And then there's a response from, I believe it's a response, because we're not constant, from Officer Shapiro that says, we're going to try to
Why
make.
don't we ask the medical examiner what she based her opinion on and what communications, because it sounds like she based it on the investigator's report. That's what you just read.
But this is the same, he made a committee. I'm not sure if that's to the.
Yeah, my understanding was there was an updated investigative report that was done early this year. That was given to the assistant medical examiner to consider as far as her opinion on matter. So council has the updated investigative report. I'm aware of nothing else.
All right, let's start with at least the civilian and the medical examiner. Yes, sir.
One last thing I want to approach.
Sorry.
One last thing I want to put the court on notice.
Okay.
Can you approach?
Sure. Okay. Are we ready to call witnesses?
You are.
Okay, let's go.
So people would first call Jeffrey Stanton.
Sir, please give your name and spelling to your court reporter. We don't have any more witnesses in the courtroom.
Give me 1 minute, Your Honor. No, we do not.
Okay. Please give her your name and spelling, sir.
Oh.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you, sir. Please have a seat in the witness box next to me. You may begin when you're ready.
Thank you, Your Honor. Good morning, Mr. Stanton. Could you please state and spell your full name for the record?
Jeffrey, Jeffrey, Stanton, Stanton.
Thank you, and good morning again, Mr. Stanton. So, first going to ask you, do you own property in the city of Detroit?
Yes, I do.
All right. And then you're familiar with this case. Is there an address of a residence that you own that's relevant to this particular case?
Yes.
And what is that?
14343 Vassar, Detroit, Michigan.
And if I showed you a picture of that residence, would you be able to recognize it?
Yes.
May I approach, Your Honor? I'm showing you what's been marked as People's Proposed Exhibit 6. You recognize that?
Yes, I do.
And what is it?
That is my property on Vassar.
People would offer into evidence what's been marked as People's Proposed 6.
Admitted.
Now, as of November 2022, did you own that residence?
Yes, I do.
And what purpose? Was it residential, or what were you doing?
Well, when I first bought it, it was residential family, and my family who lived there passed. And when they passed, I thought about selling it, and I had a friend who was doing Airbnb suggested, so why don't you do it? Airbnb, so I thought.
And then as far as Airbnb, how does that work?
Airbnb is when you have the Airbnb official site where people can go and register like a hotel to your property, and let you know where they want to stay, and they can agree to allow them to stay for a certain point of time. And all the administration is done through the Airbnb site, so you haven't to look at the transactions or anything that you have. It's all done through there. One thing you do is handle the guests that have the property.
All right. And then did you have anyone helping you with that at the residence?
Yes. When I first began, I didn't, due to my job, I travel a little bit, and I met Nas as an Airbnb customer first, and then she let me know the second time she came back as a customer that she would love to actually stay and rent a room. And I told her, I said, okay, we can have a wonderful relationship, because when I travel, I need somebody to help me straighten up for the other Airbnb customers. So she rented my downstairs room for her and her son.
All right, gotcha. And then just for the record, do you know her full name?
I never called her by her full name, I only know that, but I know it's a longer name, but I only call her now.
Okay, no problem. And then as of so November, well, let me ask you, when did she start residing?
Around, I'm gonna say September 2021.
Okay. And then as of November 2022, was she there?
Yes.
Okay. And so a little over a year she'd been living.
She stayed there for just about a year.
All right. Now, so at some point you contacted the house and you found her deceased, right?
Yes. Would you like me to give you the details?
No, we're gonna work up to that. Now, prior to that time, when was the last time you communicated with Nat?
I had a record of text messaging her the weekend before because I had Airbnb customers coming, and I always alerted her when someone would be coming in the house, who they were. Sometimes I let them communicate because I always wanted her to know and feel comfortable with who was there.
And then are you familiar with what the dates were for those communications?
I have them on my cell phone, yes, I can go back and see exact dates, but I know around the weekend of October 29th, because I had a gentleman that was working with me coming in, and he was staying there as well.
All right, and then at that time, so you were texting Naz, did you receive texts back?
I received texts back over that weekend.
Okay, and we don't need to get into what you said, but just that you texted you back. And did you have phone communication with her as well at that time?
I'm sure we probably talked on the phone. I haven't looked at that record wise, but I'm sure we talked once or twice over that weekend because my friend.
Objection, speculation, yeah.
Okay.
Sustained.
And that's fine. So as far as that phone number that you were using to send texts to Naz, had that been a number that you had used before?
Yes, that's the only number I ever had with her starting our relationship. Yes.
Okay. And just, do you remember the number off by?
I don't know it absolutely, but I can look at my phone and tell you.
That's fine. Yes. And so that number, was it saved under a particular name or anything like that?
Yes, it's saved in my phone, it's not.
Okay. And so you would actually talk to her over the phone using that number, right?
Yes.
Okay. And then you had face-to-face contact with her otherwise?
When are you referring to?
At any time. At any time, and you had face-to-face contact?
All the time,
Okay. And then, and you would talk to her in person, right?
yes.
All right. So the voice you heard when you talked to her in person, is that the same voice you were hearing when you talked to her over that phone number?
Yes.
Oh. Now, after that weekend of October 29th, did you attempt to contact Naz?
No, after my Airbnb client who I was working with left and flew out, took him to the airport, I had no further contact with her until the day I came to make sure the Airbnb area was prepared for the next guest that week.
And what day was that, do you remember?
It was, I'm just looking at my phone here, it was November 3rd.
November 3rd?
November 3rd.
Okay. Now, and what year?
2022.
Okay. And so the first contact you had, how did you contact her?
I sent you a text message, which I gave the text messages to you guys.
Okay. And then did you, not getting into, well, did you receive a response from that?
Are you referring to the weekend or the third?
On November 3rd?
No.
Okay. And then did you follow up by doing anything?
Yes, I went over after she did not respond to my text.
Okay. And so then when you went to the residence at that point in time, what did you find?
Can I just?
We'll get back to before that.
Well, it's just one key part that.
Go ahead.
That you're asking me that I communicate with her on the 3rd. I was there first before I sent the text.
Okay.
I went to clean up first.
Okay. So after receiving or after sending the text message, you then went to the residence again, correct?
That's correct. After I left from being there the first time, so I want to be clear, I sent the text, and then after I didn't get a reply back, after a little while, I got a little concerned because that wasn't her normal position, especially if I was doing Airbnb business. And so I was only a few blocks away, so I went back. And when I went back, that's when I made the discovery.
Okay. And just tell us what you discovered.
Well, when I went, and can I make this completely clear? When I went the first time, her door was partially closed But I could see her leg that she was laying on the bed. But out of respect, I did not go in her personal space. And so while I was cleaning up in the common areas, I was talking to her as if she could hear me. And then I said, well, you must be asleep. And I just kept doing what I was doing, which was no more than 10 minutes that I was there. And then I went.
All right, gotcha. So now let's just kind of jump forward.
Okay, so then.
So this is the last time, second time you went to your house, okay? So tell us what you did once you
And
got
so
to the
then when
house.
I went in the second time, I went in with concern of why she hadn't texted me. So I went in at first, I hit her door and said, nah, I've been texting you, you didn't reply. And I seen she was still in the bed, her leg there, and then I was concerned, and I opened it. And that time I opened it, as soon as I opened, I can tell in her face something was wrong. And so I, at that point, called 911.
Okay, so the door was closed?
It was cracked. You could see inside of it, but you couldn't see completely inside. And the way she was laying, you would only see her legs from the way it was cracked.
Okay, now when you opened the doors, did you actually go inside the room?
I opened the door, took 2 steps, and I did touch her leg, and I could feel the shoes cold.
Okay. And at that point, you called 911?
Yes, that's when I knew, like I said, something was.
All right. Did you notice anything else in the
Did not touch, did not go in anywhere, because I knew I had the police coming, and I did not touch her.
Did you notice anything else in the bedroom that was out of place that you noted?
I was in complete shock and fear. So once I called, I went to the front of the house, and the police was there very quickly.
Okay. Now, did you see a gun inside the room?
No, I didn't.
And did you see any ammunition, any bullets inside?
No, I didn't.
And did you, so once you called 911, then did you ultimately, were you ultimately contacted by?
Well, they interviewed me at that time, they asked me.
So you called 911 and then after that,
Then
did
the
somebody
police came.
respond?
The police came.
Okay.
And
Just
then they asked.
trying, sorry, just wait for that question to
Okay,
be
sorry.
asked and then.
Okay, sorry.
Okay, so tell us about, so how long did the police take to arrive?
I would say less than 5 to 10 minutes.
Okay, and then in that period of time, you didn't go inside the room again?
No.
All right. Now, so going back, and so I just wanted to get through that and then just go back to the first time that day that you visited the house, okay?
Okay.
Now, did you send any text message or anything like that to Naz before the first time you went to the house?
No, I did not believe that.
Okay. And just to clarify, when you went in the house at that point in time, were the doors closed still? Were the doors open or closed?
Can you repeat that whole question?
So the first time you went to the residence,
Okay.
were the doors to the bedroom closed?
It was partially closed. You could see inside and only see how her leg was hanging off the bed.
Okay. So was it the same then as it
It was
was?
exactly the same when I went.
Okay. And again, just try and wait for the question.
Okay, sorry.
Thanks. Now, when you touched, and so now we'll jump ahead to the last time you had contact with Naz. Did you get any blood on your hands from Naz?
No.
Okay. Now, were you familiar with anyone else who would stay with Naz or visit Naz at your residence?
Yes, she had a male friend that would actually be there with her mostly every time I came to the house. And I don't know if I'm giving too much information, but this was over the last 2 months after their son had passed.
Okay. And so do you know his name? Did you know?
She referred to him, I believe, as Judy.
All right. And did you ever learn his real name?
No.
Okay. Were you ever able to meet that individual?
I seen him in passing and we would say hello, but nothing of a friendship nature of communicating. Anything.
Okay. Had you had an opportunity so you talked to him and said hi, is there anything of note that Did he ever said to you?
No.
Did he ever talk about his relationship with Nas?
No.
Now, that particular individual, did you recognize him if you saw him today?
It's been almost a year and a half.
And I'm gonna ask you, do you see him?
I'm gonna say no, because I have not seen the environment of the person in a while, so I'm gonna just sort of say I can't answer that.
Okay, and just to make sure, just take a look around the courtroom, you don't see.
I don't recognize. And if I could say, I didn't see him much at the house, so like I said, her space was private. I did not get in her space, but I would see him coming in and out from time to time. So I don't know his space very well.
Understood, thank you, Stan. Just one final question, to clarify this, so 14343 Nasser Drive, that's. And then is that located in the city of Detroit, county of Wayne, state of Michigan?
Yes.
All right, nothing further, Your Honor.
Cross exam.
Thank you. Good afternoon, sir.
Good afternoon, sir.
In the first examination, you were asked questions about people that visited, you refer to it as Nas?
It's Nas,
yes. Do you remember that? Remember on the direct examination testifying about people that came to visit her at the home?
Are you referring to?
Just now.
Just now?
Yes.
Yeah, I didn't say it.
All right.
Other than her friend, yes. Yes, if you're referring to that, sorry, I didn't understand your question. I wanted to make sure I was answering correctly. Yes, the people that came, that I've seen the visitor was her girlfriend, yes.
You also knew her to have another male friend, correct?
Yes.
That individual's name, do you remember? You call telling the police that you learned that individual's name to be Lawrence Powell?
I don't recall. Sure.
What's in your written statement refresh your recollection?
What's in my written statement? I don't recall who another male name was. I do recall a male, but like I said, I did not know these people and I didn't interact with them on a name basis. So yes, there was another person. I don't recall them.
I want you to pay attention to my question.
Okay.
You spoke with the police about this incident, correct?
Yes.
And in doing so, you signed a statement.
Yes.
Correct?
Yes.
And seeing that statement would refresh your recollection as to whether or not you remember the name of the individual, the other male that would visit the home, correct?
It could help. It could. I can't guarantee, but yes.
Oh my goodness. The court would like to use numbers instead of, letters instead of numbers.
You can use that.
This defense A. Wish to approach?
Yes.
Page. Read. Anyway, you page or not? Okay. We will read this question to that answer and look at the new. Okay? Okay. Read to yourself. This is not helping press recollection.
No, I'm just trying to read it to understand it. I can't make out the words, so I want to answer what I can read.
Let me do it another way. Okay. You were speaking to the police. The date was November 3rd, 2022. Okay. 8 o'clock. Yes. That's a yes?
Yes.
That's your signature?
Yes.
While speaking to the police, you were asked the following questions, you gave the following answer. Question, has she ever mentioned an ex-boyfriend since she lost her son? Answer, yes. About him being in jail and about him being released.
Yeah.
Did the old boyfriend, question, did the old boyfriend know she was living here? Answer, yes. He was also situation.
I guess I'm gonna object to asking questions in this way. I mean, it's something that either refreshes his recollection or not. If you can't read it, then it doesn't refresh his recollection.
I'm no longer trying to refresh, I'm teaching.
I'm sorry.
I'm no longer trying to refresh, I'm now teaching since the witness said he couldn't remember. I attempted to refresh, and now that I'm asking the question in a question and answer form, it appears as if the witness is agreeing.
Your Honor, the statement that counsel is using to quote impeach isn't even an inconsistent statement.
Next, I will lay the foundation. The next question and answer is given to the crux of the issue.
You can't impeach someone when they say I don't remember.
And that's not impeachment unless you're able to show that you affected.
My understanding is that after counsel has made an attempt to refresh the witness's memory and has been unsuccessful, I don't remember and be treated as a mistake. However, I'll just go to this line right here because it's very helpful, and I'll rephrase this as such. Same page.
And no objection if counsel approaches and asks. Stand.
Proceedings. Very well. Read this line, this question here, and this answer here to yourself, and you look up when you're done.
Oh, okay. I know exactly what that was about. Yes.
Has your memory, so memory's been refreshed?
Yes, I know exactly what that is.
And the person who you remember to be the ex-boyfriend is Lauren Carli, correct?
That's what the news article says. That's what I referred to. I said it was a news article about the situation with their child. And that name had his name, and that's what it is. I didn't know his name. I knew it from the news article, that that's what it stated and what I said in the question.
Thank you. When you were talking to Nas about Mrs. Powell, she was afraid of it, right?
When I was talking to Nas about, see, I just want to say, when you saying these names, I don't know them. You just said, Mr. You got to give me a little bit, because I don't know this. So I just want to make sure you understand that I'm not trying, I want to give everything you want in regards to the question, but you got to give me a little more information instead of just Mr. Powell. I don't know him by Mr. Powell.
Okay. The person you were referring to, whose name you learned through the article.
Yeah, okay.
When speaking with Nas about that individual,
yes,
she made it clear to you that she was afraid of that person, right?
Objection, that's hearsay.
Sustained. Hold on. You mentioned Nas's son passing. You remember that?
I remember it very well.
And at that point in time, after the passing of her son, is when you saw the individual that you described as her boyfriend at the time of this incident, right?
He was there quite often, yes, after the son passed.
I want you to listen to my question very clearly, okay?
Okay.
person you saw there with Nas after her son passed was there to comfort her, correct?
That's correct.
Again, Jack, Your Honor, that tells, there's no foundation for why the person was there.
You can rephrase. Well, again, you had an interview with the police, right?
Yes.
And when you were interviewed by the police, they asked you about this person that we just talked about, right?
That is correct.
And the words that you used to describe why he was there was to comfort, correct?
Objection, whether that was in a police interview or not, it's still hearsay or no foundation.
I'll sustain the objection.
Did you say anything? I missed it. You said anything. I thought I heard you say something.
I'm not sure what you're referring to.
And the words that you used to describe why he was there was to comfort her, correct? And then he objected. Well, he objected. I thought I heard you say something.
Oh, yeah.
Your Honor, if anything was answered, I would ask to strike.
Thank you.
First time you went to the home, you didn't hear any gunshots, right?
No. No.
Second time you went, you didn't hear any gunshots.
No.
At no point in time did you hear any gunshots.
No.
No point in time did you see someone fleeing the residence the first time you went.
No.
Or the second.
No.
When you called 911, after you called 911, did you attempt to make any life-saving measures?
No, I did not go in. I did not touch him. It was a state shot. And he sat
I want to make sure I understand you clearly. The first time you went, you cleaned.
Yeah, I went to prepare for the next weekend for customers coming, as I usually did.
You cleaned, you said you called out there was no response.
Right, I talked to her from the minute I walked in from the garage door, which passes her room. And it was, hey, Nas, I'm here, I'm just gonna clean up upstairs, how you doing, such and such. No reply, I'm still walking upstairs. Went down to the kitchen and, oh, you must be asleep back there, I didn't get no response, so a few words.
How long were you there then?
I wasn't there no more than 10 or 15 minutes.
You didn't do a complete sweep of the house.
I didn't hear that.
You didn't do a complete sweep of the house. You didn't see every part of the house.
Every part of the house is my Airbnb customer space, which is living room, kitchen, and bedroom areas. That's the areas, that's the common place that I make sure aired for my Airbnb customers.
Inside of that room, where you found her later.
Did not go in at all.
I understand. Listen to the question.
Okay.
Aside from that bed and that area where the bed is there any other area in that part of the house?
No, that's just the bedroom.
Right.
And which was the door, like I said, partially closed, which was her personal space, which I didn't.
Did you go into the garage the first time?
Come through the garage, and when you come through the garage, as soon as you open the door with the garage is attached, you pass her room.
So there are other doors that can access the home.
Yes, the front door. I didn't come in the front door. I came through the back.
Gotcha.
The garage. Because when I put in my driveway, I get the garage door open in this way.
So there's a garage door, there's a front door. Is there a side door?
No, those are the only two entrances to the house.
There's not a sliding door in the back towards the.
Well, there is a sliding door in the back, but it's completely locked, sealed locked. It's not used.
Okay. You say sealed, how did you seal that?
Meaning it's screw bolted down for security measures, because it's a bedroom not using a den when you go out to the patio. So it's secure for safety.
How long before you went back the second time?
It was roughly a couple hours.
And how long were you in the home then before you found him?
The second time?
Correct.
Immediately, because I felt something wasn't right and she wasn't responding. So my purpose of going back was to see her.
I don't think I really broke it.
You redirect?
No, Your Honor.
Thank you, sir. You may step down.
Thank you, Mr. Stanton. We will call Dr. Nicole Kroon and, while waiting for, I just inquired with the court, wasn't certain if this, the last witness I can call or of course.
For your other witness.
I'm not sure the court said he can call, this didn't even.
Right.
So you can't call it?
Because you were supposed to look over the emails.
Okay.
Who are the other witnesses?
So the Detective Shakur, he'd be testifying to things regarding cell phone analysis. Then there's two foundation witnesses, Detective Markle, who extracted the phones, and then Detective Carli, who extracted video.
Okay. As it relates to the phone dumps, like the better term, I thought Mr. King indicated that he never received them.
So he's received everything now. So there was 6 files that were
King,
sent
have you
out.
had an opportunity to adequately prepare for those?
That's what I was, no. I understand that the court said to send those additional 6 files to me, but in my review, I only see the videos of the home and the second interview. Aside from that.
Okay, so we may not be able to call them. Who else do you have?
So it'll just be, so Markle, Detective Markle and Detective Shakur, we're gonna testify that. So I won't call them. The only other one I have, Detective Carli, which is testifying for video. There was a surveillance video from the house across the street. Reports regarding that, the video has been disclosed to counsel.
We don't have a stipulation as to the entry of the video. Okay. All right, please give your name and spell it to the public.
NICOCROON.
Please raise your right hand. You swear? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat in the witness box right next to me. Madam Court Reporter, you good?
Yeah, I just didn't know if there was an ME at the end. Oh, I'm a medical examiner. ME is just my title. It's not.
Thank you, Your Honor. Good afternoon again, Dr. Kroon. Thank you for your patience. So I'm going to ask you to state your full name, spelling first and last.
My name is Nicole Elise Kroon, first name NICOLE, last name CROON, as in March.
Thank you. And how are you employed?
I'm currently employed as an assistant medical examiner at the Wayne County Medical Examiner's Office here in Detroit, Michigan.
And what is your education related to that position?
So I got a Bachelor of Science at the University of California, Los Angeles in integrated biology and physiology. And then I went to medical school at the University of California, San Francisco, where I graduated with my medical degree. During that time, I also took a year-long break to get a Master of Public Health at the University of California, Berkeley. After med school, I did my 4-year anatomic and clinical pathology residency, again at the University of California, San Francisco. And after that, I did my year-long forensic pathology fellowship in Seattle, Washington at the King County Medical Examiner's Office.
All right, and then any other experience, on-the-job experience as far as forensic pathology?
Before starting work as an assistant medical examiner at the Wayne County Medical Examiner's Office, I worked as a per diem locums contract forensic pathologist at the Snohomish County Medical Examiner's Office in Everett, Washington.
And then do you, other than what you've already testified to, are there any additional trainings that are relevant to forensic pathology?
I have to do continuing medical education to stay up to date on all of the latest information in my field, but that would be the only thing.
Now, have you, so you perform autopsy as part of your duties, is that correct?
I do.
And approximately how many autopsies have you performed?
At this point, I've performed approximately 800 autopsies.
And have you ever testified as an expert in forensic pathology?
I have.
How many times?
5 at this point.
At this point, Your Honor, people would move to qualify Dr. Kroon as an expert in forensic pathology.
For these purposes, we don't object, we maintain our right to go out here and object for purposes of the trial.
All right. So for exam purposes only, the court makes a finding that this witness may testify as an expert in forensic pathology.
Thank you, Your Honor. Now, Doctor, do you recall performing an autopsy on a Nazarene by Moon Jones?
Technically, I oversaw a forensic pathology fellow at the time, Dr. El Kutu, while he performed the autopsy, but I was in the suite supervising him the entire time.
All right, so you witnessed the autopsy?
I did.
And then when was that done?
Could I have a copy of my autopsy report for that?
Yes, and actually, before I go any further, did you prepare a autopsy report pursuant to your autopsy?
Dr. El Kutu prepared the initial report. I reviewed, revised, and finalized everything about the report.
Yeah, first witness, Your Honor.
Amen.
I'm showing you what's been marked as people's proposed to. Does that look familiar to you? You just flip through the papers. First, just whether it looks familiar to you.
Yes.
Okay, and what is it?
This is a copy of the autopsy report that Dr. El Kutu and I put together.
All right, and that's a true and accurate representation of the report.
Yes.
People offer into evidence people's proposed to.
Any objection? Okay. Admitted.
Right now, just for purposes of refreshing your recollections, does that help you in determining when the autopsy was performed?
It does.
Okay, and then, so when was the autopsy performed?
It was performed on November 4th, 2022.
All right. Now, pursuant to that autopsy, were you able to observe injuries on Ms. Jones?
Yes.
And what were those?
The only injury that we found was a gunshot wound to the head.
And then what side of the head?
It was on the right side of the head.
And then were you able to determine the path of the gunshot wound?
Yes, the path of the gunshot wound was from right to left and slightly upwards.
And then was there an exit?
No.
Now, if you can, just briefly explain what is gunpowder stippling?
So a bullet is not the only thing that comes out of the end of a gun. Essentially, when the trigger is pulled,
It needs to. What are expert?
Forensic pathology.
Not in ballistics. So
Stippling is.
I believe that the testimony that is being elicited from this witness is expert testimony that should come from somebody who's an expert.
Stippling is something that you actually find on the body around the gunshot wound. At any rate, it's common that medical examiners, testify to it as part of their training and whatnot.
As far as stippling goes, I can buy that because it's found on the body. Absolutely. If you're talking about, and also
the powder would just be an observation.
Make my suggestion clear. What happens with bullets and firearms, I think it's separate from stippling. So I'm not objecting to the stippling part. When the expert is getting to how guns work and how bullets work, I'm going to object.
She can testify how it's formed.
Where stippling comes from.
And the training includes, the knowledge that it comes from the actual gunpowder.
You may proceed.
So maybe just continue from the start, Doctor, if you can explain gunpowder.
Okay, so sibling is the unburnt gunpowder particles that come out at the end of the gun when it's fired. And those unburnt gunpowder particles can strike the skin, which leave little abrasions that we call stippling.
And were you able to make any determination whether there was any stippling on Ms. Jones?
No, there was no stippling present.
Okay. And was there any gunpowder used?
We did not observe any gunpowder.
Oh, and then just as far as around the wound, there was no gunpowder?
No.
Okay, what about anywhere else on the body? Did you observe any gunpowder?
We did not observe any.
Okay. Now, as far as range of fire, is there anything you can take from the presence or non-presence of stippling?
In forensic pathology, we give estimates as to range of fire based on the presence of certain features like soot or stippling. And we have general estimates with regards to handguns with the presence of soot or stippling, but really to make an accurate determination of range of fire, test firing has to be performed on the suspected weapon by a ballistics expert.
Okay. With respect to a handgun, what can you say as far as?
With respect to a handgun, usually we will see soot when the gun is within 6 inches of the victim, but it can be seen up to 12 inches away. And in terms of stippling, we generally say about 30 inches, but depending on many different factors with the gun, which I would defer to a ballistics expert about, can impact whether stippling can be present farther out than that.
Now, did you locate any other injuries on Ms. Jones?
No.
And did you look for any other factors or did you make any other observations of anything that could have contributed to Ms. Jones' death?
No, we didn't see any evidence of natural disease or injury internally that could contribute to her death.
And then were you able to form an opinion based on your observations and your examination as far as the cause of death?
Yes, I determined the cause of death to be a gunshot wound to the head.
Now, do you know the date that Ms. Jones' body was actually obtained by the medical exam?
I know she was pronounced on November 3rd, and after our scene investigation is performed, a transportation service picks up the body and brings it to the office. So November 3rd will be the date.
All right, and then is anything done with the body when it's first taken into the possession of the medical examiner's office?
After the body is checked in, we store them in our refrigerators to prevent further decomposition.
And to your knowledge, was that done in this case?
Yes.
All right. And then, so then based on your examination, were you able to make some determination as to when what's the time of death, date of death?
In general, there are a lot of factors that play a role in decomposition, namely environment and also decedent characteristics such as body habitus. When we see decomposition changes such as gray green discoloration of the skin and folate formation and skin slippage, generally we would estimate those changes to occur between 60 and 72 hours after death. But in this case, the decedent was obese, which can speed decomposition. She was also found on a mattress, which can provide insulation and increased temperature, which can also speed decomposition.
And then so 60 to 72 hours
would be a very, very rough estimate.
Okay, and then based on those other observations you made, would you, I guess, enhance that estimate of 60 to 72 hours?
suspend, refer.
So doctor, you indicated that obesity would be a factor and then there's other factors, correct?
Correct.
Okay. So based on those factors that you saw with respect to Ms. Jones, would you be able to give a more exact, I guess, estimate as far as time that?
Given those factors, my time of death estimate is probably a little farther out than might have been if those other factors weren't into play. But again, time of death estimations are highly dependent on those environmental and decedent characteristics. So, you know, baseline the estimate is really rough.
All right, that's fine. Now, did you also indicate in your report manner of death?
I did.
Okay. Now, what do you base that on when you determine manner?
Manner of death is a public health classification system to give more details about the circumstances surrounding a death. So when determining the manner of death, I take into account our medical examiner investigator report. Our medical examiner investigators are the ones who actually go out to the scene. They document decedent characteristics. They speak with law enforcement on the scene, any witnesses next of kin to get all the information surrounding the circumstances of the death. I can also request law enforcement reports, EMS reports, medical records, all of those things help to provide some information about the circumstances surrounding the death.
All right. And now, as far as your opinion, as far as the cause of is that dependent on any of those factors you just mentioned?
Cause of death is determined based on my autopsy, toxicology, whatever other ancillary study.
Okay. And then the manner of death in this particular case, could the manner of death be determined solely based on your medical examination?
No.
Now, in this particular case, what was your initial indication as far as manner?
My initial manner was indeterminate.
Okay. Now, was that ever changed?
Yes.
Now, first of all, let me clarify, when was the initial report written?
In November of 2022.
Okay. And just to clarify, did you write it or did the fellow?
Dr. Al-Kutu wrote the first draft. At that point, I revised, reviewed photos, his autopsy diagrams, et cetera, and then I finalized the report.
Okay. And at that time, the manner of death was determined. Okay. And then when was it changed?
I believe I asked for additional information in January 2023, and then subsequently amended the manner in September of 2023.
And who did you ask for information?
I initially asked our medical examiner investigator for more information if she could obtain an updated investigative report from the law enforcement side. And she was able to obtain that through Sergeant Kenneth of the UPD Homicide Department. So it was emailed to me.
Okay. And did you receive any information from any other sources?
Yes, that investigative report had pretty much the same information I had gotten initially. So I asked if there were any updates in the investigation, if I could be directed to the officer in charge so I could ask. And Sergeant Kenneth contacted him and then forwarded an email. So I got additional information from the email.
Okay. And then with respect, at that point in time, what did you change your manner of death to?
At that time, manner of death was amended to suicide.
What was the additional information that caused you to change that?
Do you have my addendum that I can mention?
Yes. I'm showing you what's been marked as people's proposed degree. Do you recognize that?
I do.
What is it?
This is an addendum that I wrote for this case.
Oh, and offer into evidence what's been marked as people's proposed degree.
Okay. Admitted.
Great. And then so just again, would that help refresh your memory as far as determining what the factors were or additional information?
Yes, I wrote the additional information that I got in my narrative.
Okay, what was that?
So I was given information about some text messages that were exchanged between the decedent and her boyfriend. And the context of those texts was such that it implied that suicide was the probable manner of death in this case.
Okay. Now, subsequent to September 2023, did you happen to change that determination?
Yes.
And what was the reason for that change?
I was contacted by Detective Shakur, who had some updated information regarding the investigative findings for me.
And based on that information, what did you change your finding?
I changed my finding back to indeterminate.
And I'm showing you what's been marked as people opposed for. Take a look at that. What is that?
This is the second addendum that I wrote.
And so people to offer into evidence, people proposed for. What?
Admitted.
So what additional information did you receive to make you change your finding?
The most significant piece of information I received was more information regarding surveillance footage from around the time of the decedent's death.
All right. And was there any other information that you had received?
Yes, there was information that some handwritten items that were of concern were being analyzed, the results of which were not in the report that I received. There was also mentioned in the updated investigative report that a suspect had their residence searched and found some bullets that were consistent with the one used in this case in his possession, as well as a weapon that was of a similar caliber.
All right. Now, again, this is all information you received, right?
Yes, in the updated investigative report that was sent to me in February 2024.
And it was information you received from investigators, right?
From law enforcement investigators, yes.
Okay. You yourself were now conducting an investigation on what happened, right?
Correct.
All right. And then, so as of today, what's the finding with respect to Ms. Jones' manner?
So as of today, her manner of death is indeterminate.
Now, just moving on, were you able to determine any other conditions, medical, otherwise, as far as Ms. Jones is concerned?
She had an intrauterine pregnancy.
And what does that mean?
It means she had a pregnancy within her uterus.
And were you able to determine how long she'd been pregnant?
So at autopsy, there was no macroscopically viewable fetal tissue, so nothing that looked like a human form. So we took samples of the tissue that was present in the uterus and looked at it under the microscope and confirmed the presence of chorionic villi to confirm the pregnancy. And so given the stage where there were no humanoid features, the embryo would have been less than 12 weeks.
And so it was determined to be an embryo inside Ms. Jones?
So given that there were no humanoid features, and given the histologic characteristics, yes, this would be the embryonic stage of pregnancy.
And then in your evaluation, were you able to determine or make an opinion as far as the cause of death of the?
So since embryos aren't independent living beings, they don't have a death per se, but in this instance, based on the microscopic characteristics, it is likely that the pregnancy was viable at the time of the decedent's death.
So what's the term you use then as far as the status of that embryo at that point? examine Ms. Jones?
No longer viable.
Now, was a toxicology performed on Ms. Jones?
Yes.
And did you do that yourself?
No.
Are you a toxicologist?
No.
I'm showing you what's been marked with people close by. Does that look familiar to you?
Yes.
And what is it?
This is a copy of the Stevens toxicology results.
And do you know who performed that toxicology analysis?
I don't know specifically who did, but we send all of our samples to NMS labs.
And what are the samples that you send in?
It depends on the state of the decedent. In this case, we were able to get peripheral blood, so we sent that for testing. We were also able to get vitreous fluid, which is the fluid inside of the eyeballs, and we were also able to get urine.
Okay. And then based on what you have in your hand, People's Exhibit 5, sorry, I moved it, or I'd offering to have People's Exhibit 5.
Any objections? No. You did?
So based on what you have in your hand, are you able to determine whether that's Ms. Jones's blood analysis or not?
So the case number matches, the patient ID number matches that of the Wayne County Medical Examiner's office, so yes.
Okay. And then in your non-expert opinion as far as toxicology, are you able to determine whether any alcohol was found in her system?
Ethanol was present in her peripheral blood, and ethanol is beverage alcohol, the type of alcohol that's in beverages.
Okay. And were there any other substances found in the
There were also THC metabolites, and that's the active ingredient in marijuana.
Okay. Now, as far as the substances and the alcohol, are there causes other than consumption that can be a reason for those being present?
Yes, ethanol can be produced by decomposition. So endogenous production of alcohol.
That's within the scope of her expertise.
You get the objection. You know, I believe that the witness testified this is not an expert in toxicology, and I'll give an expert opinion on toxicology.
Does that fall in the toxicology or you as an expert in toxicology you testify?
I'm able to testify as to decomposition and the changes that occur with that, which are within the realm of this question.
Thank you. Sorry, can you respond again? As far as what would be the causes? Are there other causes other than consumption?
Yes, as a body decomposes, it can produce ethanol.
Okay. And ethanol being what?
Ethanol being the type of alcohol found in beverages.
All right. Now, and just yes or no, are you able to make any kind of opinion as far as the level of intoxication or how that person was affected by the substances you find?
No.
All right.
How much ethanol was found?
According to the report, 0.277. So a blood alcohol content is 0.277%.
So the body had to be decomposing for a long period of time to have a alcohol content that high.
So the only study that I was able to find was from 1993 and included about 300 decedents. And the highest level of endogenous production that they found was 0.07%. So the majority in this case would probably have been exogenous.
In other words, the ethanol that was found was probably not just from decomposition, but from consumption.
Correct.
No further questions.
Cross that.
I want to talk about the testimony you gave with regards to the estimated time of death, okay? Now, in your review of the evidence in this case, you had the opportunity to go through the death certificate, right?
I've produced the information on the death certificate.
All right. And as part of the death certificate, the information includes an approximate time of death, right? That's a yes?
That's a yes.
And also an approximate time of injury, right?
Yes.
And there's also a line in there that speaks to the approximate interval between the onset and death, correct?
Correct.
That's the onset of the injury and the death?
Correct.
Meaning how long it took someone to die after receiving the injury.
Correct.
All right. Now, the death certificate that you produced is completely different than the testimony you provided today with regards to time of death and date of injury, correct?
Not sure I don't have a copy in front of me.
Let's talk about it. When you did this medical certificate of death, part 28A asks the actual or presumed time of death, and you wrote unknown, correct?
Yes.
And when you did this, they asked for the date of injury, being month, day, year, and you wrote again, unknown, correct?
If you say so.
Now, approach with defense exhibit B, as well. I'm approaching with us to mark as defense exhibit B. Please read to yourself as I read out loud, okay? This here says medical certificate of
Your Honor,
death.
this is to press the recollection. Is that correct?
It's not. She said if I say so, it would make consistency. No.
She said, I would take that as she's not sure.
I thought you were trying to refresh the recollection.
I would look for one speak to that.
I don't know what you're doing.
I would like to suggest to you to
You give her an opportunity to look at what she wrote and then you refresh your recollection. And if you have something to impeach her in that, go for it.
Absolutely. It's been admitted, so I'm gonna go through it after she's also want to admit it, and then we'll go through it. So I'll let her. Remember the request?
Yeah.
You recognize the document, correct?
I do.
That's the document you created?
Technically, no. One of our administrative assistants creates the document. I just sign it.
Okay, so. This is a clear and accurate depiction of the document that you recall? You signed it?
As far as I recall.
Move to adjourn.
No objection?
All right, this document says,
What's he?
D is a problem. Medical certificate of death, right?
Yes.
And on here it says Nicole Kroon. That's you, right?
That is me.
And as you just read, the date of injury read unknown, correct?
Correct.
Time of injury unknown, correct?
Correct.
Approximate interval between onset and death unknown, correct?
Correct.
You would agree with me that that is different than the testimony you just provided?
No.
Okay. Something changed, right? No?
No.
So why didn't you put any hours or estimated time of death on the death certificate?
That's not standard at our office.
It's not.
Not standard at any office I've worked at.
So it's your testimony that in your experience, if you have an estimated date of injury, you don't put that in the death certificate?
I've not seen that at this office.
My question to you is, in your experience, have you, when you've seen dates of injury that cause death, you haven't put that in the death certificate?
Usually that information is only filled out if it's something like a motor vehicle collision where we have witness statements, surveillance video, et cetera, that can give us an exact time and date of the incident. If we find somebody decomposing, as I said, There are a lot of things that impact time of death estimates, which is why we don't give them, such as environment and body habitus, other decedent characteristics. So what we put on the death certificate is typically information that we have for sure.
Okay, so you don't know for sure what the time of death, what date of injury was?
Correct.
Okay, so the testimony you just gave today is your opinion, it's not you saying to the court that you know when this injury occurred, correct?
The information I provided is an estimate as to time of death based on the decomposition that was present at the time of examination.
So that's another my question. You don't know the date of it.
No.
And with regards to the death certificate also says an autopsy was performed, right?
Yes.
You were present when the autopsy was performed, right?
Yes.
Did you see any signs of things that would contribute to the estimated cause of death that you testified to today?
Can you repeat that question?
You performed an autopsy, right?
Yes.
And this death certificate was created after that, right?
Yes.
You were present both times. Yes.
When the actual death certificate was produced,
You signed it.
I signed it,
You
yes.
reviewed it and you signed it.
Yes.
You had the opportunity in this document to make an estimate based on what you just saw in the autopsy, correct?
Theoretically.
Theoretically. You saw it, correct?
I saw some postmortem decomposition.
Now my question, you saw the certificate, correct?
Oh, yeah.
After seeing the body, correct?
Yes.
And you had the opportunity to edit this before you signed it, correct?
Yes.
And you did.
No, I can object if that's an answer. You
I'm
seem to
moving.
be clear on direct that it's an answer.
Gunshot residue. You testified on direct examination that you didn't see any gunshot residue on the body. Do you recall that?
I testified that I did not see soot or stippling on the body.
Okay, so it's your testimony. You didn't testify to any gunshot residue.
I did not testify about gunshot residue.
You didn't testify on any gunshot residue because you don't know whether or not there's gunshot residue on the body, correct?
Correct.
Because you or your office didn't test for gunshot residue, right?
We don't do that testing.
So the answer to my question is no.
Yes.
Okay. There were swabs taken of the hand, though, right? Of the decedent's hand?
We took fingernail clippings.
And swabs.
I'd have to refer to my report to see if I noted any swabs were taken or the evidence log to see if any swabs were taken. I do not recall off the top of my head.
Let's do this. You see the man that's left out here? The man just walked out here?
Oh, did I see him walk out?
You know who this is? The officer that's got up here up and walk out.
I'm assuming that's Detective Shakur, but I only met him once, so I'm not sure I remember what his face was
Okay.
like.
Well, you remember talking to someone named Detective Shakur, right?
Yeah.
Let's talk about the circumstances of those conversations and your findings, okay?
Okay.
Now, you testified that you based your opinion on your opinion as to the manner of the ME investigators, right? That was one of the things you cited?
Yes.
Obviously the body of the decedent, correct?
Correct.
And your conversations with law enforcement, right?
Email correspondence with law enforcement.
All right.
And then the law enforcement meeting.
So when you first gave an opinion, You hadn't spoken to this man, right? As to the manner of death, right?
No.
You did speak to any investigators, right?
Yes.
Do you recall if you spoke to any other officer at that point in time?
No.
And again, at that point in time, the manner of death was indeterminate, right? Let's move forward to the first addendum. First addendum you spoke to somebody from law enforcement, right?
By email correspondence.
With who?
My initial contact was Sergeant Kenneth.
Wasn't with the man that's sitting in the seat, right?
No.
Okay. And you still had conversations with medical investigators again, or just the new law enforcement officer?
So I emailed our medical examiner investigator to see if I could get a copy of the law enforcement report to see if there had been any updates since the information had initially been given.
Mm-hmm.
She reached out to one of our contacts in homicide, Sergeant Kenneth, and he was able to send me a copy of the report, at which time I had some follow-up questions. So I emailed him to see if I could get in contact with the officer in charge of the case to see if there had been any updates. At which time.
Just look on for a second. I just make my record. I don't have the communications between her and officer. Continue.
At which time Officer Kenneth forwarded an email to me from Detective Shakur with more information regarding the case.
All right. Now you're saying more information about the case. I'm gonna put a pin in that. But after you spoke, after you received said information from, say the officer name again, not sure who's the other one?
Sergeant Kenneth.
Sergeant Kenneth. The manner of death was suicide.
I changed the manner to suicide, yes.
Now, was it genetic or was it secure that told you that the investigation findings suggest that Mr. Moore went into the house, found the decedent with the gunshot wound to the head, and freaked out because he had given her a gun for protection? Which one was that?
What email was that?
Yeah, who sent that?
That was from, I believe, an email from Detective Shakur.
You believe?
I obviously don't have my email on here for reference.
This is what people are talking about. Do you recall if it was Shakur or what's the other guy's name?
Sergeant Kenneth.
Sergeant Kenneth, that then told you law enforcement believed that Mr. Moore removed the gun from the scene because he's a felon and he feared he would face criminal charges for possessing the weapon.
That was again from Detective Shakur.
Sure.
Yeah.
That's in the report, right?
It was in my addendum, yes.
And the addendum is report. Am I wrong with it?
It's part of the report.
Okay, so that's my question is that. That's part of the report, correct?
Yes.
Okay. Now, you said something about this last addendum. It's right there. You said there was something different about the first addendum. You would agree with me that in both the initial autopsy narrative and the first addendum, there was references to text messages between the decedent and Mr. Moore, right?
Yes.
And as you listed in your report, during the exchange, the decedent texted him, you said I didn't have the balls to do it, goodbye. And then Mr. Moore texted her to stop talking crazy and he was going to come back later. Recall that?
That was the information I was provided.
That was also in the initial autopsy narrative, right?
The initial text messages, I have to review the report.
Absolutely. Yes. I want you to, Madam Clerk, Your Honor, can you look at what's been admitted as People's Exhibit 2, first paragraph? Strike. Not first.
My summary and opinion is missing from that copy of the autopsy.
Gotcha,
report.
okay, I thought something was wrong. Yeah. This is the second paragraph of this page. Last 3 lines.
It does look like I quoted those text messages in this report.
So that didn't change, right?
Right.
Then, after speaking to Detective Shakur,
Yes.
Detective Shakur, you said you received some more information, right?
Yes.
Let's talk about the information that you received. There was information about an alleged argument between Mr. Moore and the decedent on October 30th, right?
I don't know that it was Mr. Moore. It was just reported to me as the decedent's boyfriend.
Yes, boyfriend, I'm sorry.
Yes.
All right. And the argument was about the decedent being pregnant, right?
Reportedly.
I like how you use that word, right? Because you don't even know who said that, right?
I wasn't present at the time.
I'm saying you didn't see anyone's written statement saying that they heard an argument, right?
Not initially.
When have you seen a written statement saying that the person who heard that wrote a statement?
I'd have to review the first investigative report.
We'll get that to you in a second. But you're saying you remember reading a statement from someone saying they heard that argument between those two?
That was the information my medical examiner.
Right, that you received from
our investigator. Right. Yeah.
That was in the first summary and opinion, right?
What information?
The information-
The fight?
Correct, the argument.
Yes, that was information in there.
And that information was still known at the time of the addendum, which ruled the manner of death as a suicide, right?
Right.
Let's talk about what was added to this third report. There was according to you, examination of the scene revealed a handwriting note in an open notebook beside the decedent, which appeared to be a suicide. Do you remember that?
Do I remember writing that?
Yes.
Yes.
All right. Upon review of the notebook, it was discovered to be a diary. Remember that?
Yes.
I'm writing that when I thought. Then there's a line right after that's in the report that says the handwriting of the prior entries and various handwritten items throughout the house did not appear to match the writing of the suicide note. Remember writing that?
Yeah.
Who told you that?
That was in one of the investigative reports.
The one that Shakur wrote?
I don't know.
You know he's not a handwriting expert.
I don't know that.
But he hasn't told you that. What's wrong? He hasn't told you that he was, right?
Objection, Your Honor.
What's the objection?
Like, the subject of whether he's an expert.
I said, if he told her that, I'm not, this is a hearsay, because I don't think there's a statement this was well. You want to ask a question?
Yes.
He never told you that he was an expert?
No.
Do you, you can just answer this question as to whether or not you know or not. Do you know that the Michigan State Police has a department that actually does handwriting analysis?
Yes.
Okay. Before you created this report, actually you referenced in this report that the handwriting analysis was sent out to the Michigan State Police to determine if that handwriting matched, right?
Yes.
However, you didn't know the conclusions of that analysis before you submitted this report, right?
Correct.
Because Shakur didn't give it to you, right?
They were not in the report, and I have no reason as to why.
Who gave you the report?
It was sent to me by Detective Shakur.
And again, when you got that report, it didn't include any findings from the Michigan State Police Department.
I can't say any findings. I know the results of a handwriting analysis were not in there.
Then they gave you a date, October 31st, 2022. There was a suspect. You would agree with me, that's different. That word suspect is different than the word person, right?
Correct.
Okay. Suspect gives the insinuation that this person is probably doing something wrong, right?
Yes.
Says a suspect walked to a garage the suspect was observed coming out of the garage of the incident location. Remember writing that in the report?
Yes.
That again, that's not information that was listed in the first narrative or the second report, right?
Correct. This was information in the updated investigative report that I received from Detective Shakur.
That date, October 31st, 2022. What did that mean to you to put that in this report?
I believe that was the initial dates that were mentioned regarding the surveillance footage. So I put in dates that were mentioned from that actual investigative report.
That doesn't mean to you that that's the date of this incident, right?
Correct.
That's not what you meant when you put that, right?
Correct.
Then on November 1st, 2022, the same possible suspect returned and attempted to use the keypad, but appeared to be unsuccessful and unable to enter the location via garage. Remember writing that in the report?
Yeah.
When you wrote November 1st, 2022, you again were not writing that that was the date of the injury, correct?
Correct.
Or the date of the death.
Correct.
Then you made a statement in your report that says that no weapon was found at the scene of the incident. Yes?
Yes.
And a gun with the caliber consistent with the weapon used at the scene was eventually found during the search of the possible suspect's residence. Remember writing that?
Yeah.
Now let's talk about that sentence. Because again, that came from who?
The investigative report.
Which came from who?
Which was written and linked by Detective Shakur.
At least you received it. If you didn't write it, you got it.
Correct.
Okay. It says a gun matching the same caliber was found at that residence. You don't know if that was a handgun or a long arm rifle, right?
No.
What if I told you that was an investigation report, that it was actually a long arm rifle? Did that change your opinion?
Objection, Your Honor.
I'm talking about opinion.
Those are facts that aren't in evidence.
It's okay, she
You
can get
choose your basis.
She can get hypotheticals on the road.
If I were to give you a report that says that the only gun found at that suspect's residence was a long arm rifle and not a handgun, would it change some of the opinions that you have in here on this last addendum?
It wouldn't change my ultimate opinion.
It would change some of them.
I probably would have left that information out of the addendum or mentioned it as non-contributory.
Gotcha. So what if I showed you one of the investigative reports right now? That's what was actually found inside of that suspect's home. Would that help you to determine whether or not you would omit that from that piece of information from your report?
Probably not.
No. I'm confused because your testimony is confusing. You said if I showed you, if you had seen information that there's actually a long arm microphone, not a handgun, that you would probably just omit that line about the caliber of bullet being found in the suspect's home. Is that what you said?
I said I might omit that line.
Oh, now you're saying you won't.
I said if you showed me that right now, it probably would not change my ultimate opinion as to cause and manner of death.
So you see what happened there? You go back to cause and manner. I'm talking about that line about them bullets at that house.
I can't say whether or not I would have included the information since I never got the information about the rifle.
Gotcha. You familiar with calibers of bullets?
I'm familiar with them.
Yes.
Yes.
What's the bullets? We also talked about stifling. Remember that? Stippling. How do you say it?
Stippling.
Stippling. Stippling. And stippling, you say, is gunpowder residue that hasn't been burned, right?
Yes.
So I'm just start saying GSR as far as gunshot wounds, okay?
Okay.
So when talking about potential GSR, I want to be clear. Did you check the fingernail clippings for stiffening? I'm sorry, the fingernail clippings from the decedent. You check those specifically.
Stippling would not have been present underneath the fingernail. Stippling is clusters of abrasions that are around the gunshot wound or areas of the body that were near where the gun went off at the time it was fired.
What about gunshot wound? That's what I'm saying. Check the decedent's fingernail clippings for gunshot residue?
No.
Oh, there are a lot of things that can contribute as to whether or not stippling is found on the body, right?
Correct.
What are some of them?
Some of those are the characteristics of the gun. Many things about the gun can change the range at which stippling can be seen.
Let's stop there. So we talked about calibers of weapons, right?
Yes.
You know, there's a 38 caliber weapon, right?
I have heard of 38 caliber weapon, yes.
There's a 40 caliber weapon? No? Okay. The caliber of the firearm could contribute as to whether or not there's stippling found on the body, correct?
I don't know of caliber specifically, but I know the cartridge can have an impact.
Right, so the cartridges are the calibers and diameters of cartridges. You don't know that?
No, I know that caliber is a diameter.
Okay, so a 9mm caliber is smaller than like a .38, right?
Yes.
And the .357, correct?
I'm not a ballistics expert.
Okay. But the caliber that was found in this situation was a 9mm, right?
That's what was reported.
What do you mean you said? It's not what it looked like to you?
The bullet itself?
The bullet wound, the entrance wound in the bullet itself, it didn't look like a 9mm?
You can't tell caliber from the characteristics of a gunshot wound.
But the caliber determines how much gunpowder is in the actual bullet, right? You don't know. I'll move on. You made mention of stippling and soot. I think you said stippling can be found 24 inches, something like that, in the body.
It's highly dependent on the cartridge, but the average is 30 inches.
So you said average, so that's dependent, so let me make this question. When you say the average, you talking about all bullets or specifically 9mm?
I'm talking about all bullets.
Okay, so let's talk about 9mm. Do you know that or no?
No, I'm not a ballistics
All right,
expert.
so you don't know how far within inches a 9mm will leave stippling on a body?
Nobody can know since all of those are specific to the gun. You have to do a test fire of the actual weapon to get those definitive.
Was a test fire done here?
I don't know.
Let me make my question pointed and clear. You, yourself, as you sit there today, have networked, done a study on a number of just 9mm bullets to determine exactly what the estimated range is when you release stippling.
Correct.
Thank you. Now, let me ask you this. Did you measure the length of the decedent's arm to see if it was, to see how long it was?
No.
So you don't know if it was 24 or 30 inches? No. That's not something you guys do with your own?
No.
Why not? That's not important to a cause of death?
It's not standard protocol.
It's not important to a cause of death.
And it's not in our protocol. Let's say no.
Okay. You would agree with that all clothes should be examined for gunshot residue on the body, right?
You know, she already testified, she's not an expert in gunshot residue.
I'll move on. Evidence of contact range. You know what contact range is?
Yes.
What's contact?
Contact is when the gun is pressed up against the stand.
Evidence of contact range and stippling, those things can be effective if the wound is cleaned or shaved before you view it, right?
Yes.
Did you shave or clean the wound? Well, excuse me, sorry. Was the wound shaved or cleaned before you saw the decedent?
No.
And you base your opinions on police reports, right?
Which opinions?
As far as matter of death.
As far as manner of death, I take multiple records into account. One of them being police reports.
Actually, strike this. I'm sorry? Strike that one. The trajectory of the trace trajectory of the bullet that went through the decedent was from right to left, right?
Correct.
You know if the decedent was right or left-handed?
No.
And slightly at an upward angle, correct?
Correct.
In your experience, when someone is taller or at a level higher than the decedent's body, the trajectory of the bullet will go down, right?
Depends on both the position of the shooter and victim.
Nonetheless, there was nothing to suggest that the trajectory of this bullet was up to down. It was down to up.
It was going upwards.
And how many times you say you testified as an expert before?
This is my 6th time, so 5 times before.
In those 5 times before, did you have 2 separate addendums giving different manners of death in any of that?
No.
You said the gun was never there. There was never a gun found, right? In your report?
There was no gun at the scene.
Yes.
Correct.
To your knowledge, there's not been a gun found in this case at all, right?
Sorry, what was that?
To your knowledge, there has not been a gun found in this case at all, right?
Besides the gun found at the residence of a potential suspect, I don't know other gun.
Right, but you don't know if it's a handgun or a long arm, right?
No.
Okay. So you, as you sit there today, cannot say that the wound that you saw that caused the death of the decedent was inflicted by a 9mm gun, correct?
Correct.
No further questions.
You redirect?
Great there. So Dr. Kroon, first with respect to your first addendum, People's Exhibit 3, counsel asked you about the text messages that you included as far as changing manner of fact. Remember that?
Yes.
Was there something else in that first addendum that you considered in changing manner?
I would need to have it for reference.
So to help refresh your memory and read.
The additional information that was reported about where the gun had come from and why it might have been removed.
Okay. Was there any speculation that was indicated to you about what the suspect may have done?
You just gave my objection. It's speculation.
I'm talking about what was the information given to
The lady sounds like speculation. She's about to speculate.
just one second.
If it formed the basis of her opinion.
Oh, I'm sorry. My apologies.
No, you already asked the question. Feel free to refer to Exhibit 3 if it helps refresh your memory. So did any of the sources you talked to prior to doing your addendum to People's 3, did any of the officers or the information include to you their thoughts on what may have occurred?
Yes.
What's that?
Based on their investigative findings, it's believed that the boyfriend went to the house, found the decedent, had given the gun to her for protection and subsequently removed it because he is a felon and feared he would face criminal charges for possession of said weapon.
Okay. Now was that something that you knew, or was that information that was given to you when you did your initial medical exam?
Not that I recall.
Oh. And was that, and that information, was it specified where that information came from?
It says according to electronic correspondence, so it was an email with law enforcement.
All right. Did it indicate like whether it was from an interview or how they came about to offer that explanation?
No further details are not provided.
Okay, thank you. And then with respect to the second addendum, counsel asked you about some of that information. He asked you about a firearm that was found, it was reported to be found in the defendant's residence. You recall that?
Yes.
Okay. Was there other information?
He is a defendant. I know, but the term that I use is that she answered the suspect. I never said.
Was there some other information about something else that was found in the suspect's house that you could say, other than the guns? Was there something else they indicated that? What was that?
In addition to a firearm, they found blue markings present on bullets found in the residence, and the marking was the same as those found on the spent casing and live rounds found on the deceased's bed at the end of the scene.
Okay. Now, was that something that you knew when you did your original medical exam?
No.
And was that something you knew when you did your first?
No.
This is your second, right?
Yes.
All right. And then finally, what's the difference between gunpowder gunpowder residue and gunshot residue and gunshot powder?
I'm not sure of the technical definition for gunshot residue, but I know it's swapped for and tested for, whereas soot and stippling are things that we've seen in the body that can indicate a range of fire.
Okay, thank you. Nothing further.
Three questions, please. There. Okay. The first addendum that you just read, said that they told you that the decedent was dead when Mr. Moore arrived, correct?
Yes.
And that information came from the police, right?
Yes.
And the blue bullets, the lining on the blue, you don't know on the shell casing, you don't know how common that is with regards to firearms, do you?
No.
Okay.
Thank you, Dr. You may step down. Appreciate your time.
Your Honor, I have one for the witness, go ahead. No, this is just regarding the video. Can I talk down? So Your Honor, just have a witness to testify to extract the video, playing video about.
We need to hear from the witness. Video.
People call Detective Anthony Carli. Antonio Carli. While doing that, can I offer exhibit? People would offer people's proposed one. This is a criminal conviction of the defendant from Macomb County.
It's what?
A criminal conviction of the defendant from Macomb County.
Yes. Any objection?
I think we just certified this. I'm sorry. If it's certified, no, I'm not objection.
Admitted. So please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth. So, yeah. I do. Thank you, sir. Please have a seat. You may begin when you're ready.
Good afternoon, Detective. Can you please state your full name, spelling first and last?
Antonio Carli, Antonio Carlisi.
Thank you. How are you employed?
City of Detroit Police Department.
And what's your position with the Detroit Police Department?
I'm a detective within the homicide unit.
Now, on November 7th, 2022, were you working?
Yes.
And regarding this case, people versus Gabriel Moore, were you given, do you have any duties with respect to this case?
On that date, I received a DVR from Officer Shakur to recover any video for a certain time period.
All right. And did you have any information as to where that DVR came from?
Yes.
And where did it come from?
From a house located at, referring back to my report for the address, it was 14405 Vassar.
I have several objections. I believe I have several objections. I believe they're going to try to admit this, and I don't think this officer can lay a foundation to this. Or
are you objecting in advance because you haven't even given an opportunity?
Well, I heard that he received it from Detective Shakur, and Detective Shakur is testifying. So first, it's basis of knowledge hearsay. That's my first objection. Second, you guys in first-hand personal knowledge of what this shows or any ability to authenticate the timestamps.
So Your Honor, the foundation, this is the foundation question. So it's not hearsay, it's only offered for foundation purposes. Ultimately, the video is going to speak for itself. Wherever it came from, the video is going to show what it's
trying to elicit from this witness.
That he extracted the video from the DVR system. The system was located.
Okay, so why aren't we
located
asking those
across.
questions?
Pardon me?
Why aren't we asking those questions?
I can move on. That's fine.
I just want to be clear. How can I sit down? Just wanted to hear this witness say that he got the DVR from Detective Shakur. If that is correct, then my initial objection is in his basis of knowledge about anything that's on that DVR is hearsay. Like if I were to ask this court, can you go and get this video footage from Coney Island, and you ask me when is it from? I said, oh, from March 8th, 2022. Like you wouldn't know that or be able to.
He can testify as to what he did when he did it at that time.
There's going to be further testimony that's going to establish that this video is going to show, the time period as far as when the homicide.
Let me just proceed. Ask the question.
So, Detective, what did you do with respect to that DVR?
So first, what I would do is look at the DVR, plug in the DVR into the monitoring system, and record the timestamp to say that it's accurate, if it's fast or slow to the world clock. And this DVR was 43 minutes fast to the world clock.
Okay. And then how do you determine that?
Again, by looking at the timestamp from the DVR and going off the world clock.
Okay. Now, did you have any information as to whether that would be off at all? Whether 43 minutes, whether that was exactly the difference, or could it vary?
No, that's 43, it was off by 43 minutes.
Okay. And then what did you do with respect to extracting the video?
I then extracted the requested video using the DVR examiner software because there was a large amount of, there was 3 days in question, starting at October 31st, 22, about 5:30 in the morning to the 3rd of November, about 8 p.m.
All right.
So that was extracted from the DVR.
All right. And then with respect to video footage on November 1st, 2022, were you asked to extract that?
Again, yes, from the 31st through the 3rd, I extracted all that video.
Okay. And then, and so was it for the whole day of November 1st, 2022, you extracted?
Correct.
All right. Now, if I showed you the video that you extracted, would you be able to identify it?
I could.
And you're just for purposes of Detective Carli identifying the video, asking to show the detective, not offering. All right. Thank you. I'm trying to find myself.
Here. All the publishers, I need to say you want to identify the witness.
May I can approach the witness to show it, or I can put it on the screen, Your Honor. It's up to you.
Put it on the screen, I'll turn it back.
For the record, this is People's Exhibit 15, proposed Exhibit 15, and then starting at 23 minutes and 30 seconds. Video. Correction on the time, 23 minutes and 31 seconds. For the record, I'm just pausing video at 33 minutes and 38 seconds. Detective, can you see that video on the screen?
Correct.
Okay, and you recognize that?
Yes.
Is that true and accurate representation of the video that you extracted?
Yes.
And then I'm just gonna skip ahead. Go to 32 minutes and 10 seconds. Thirty-two minutes and 6 seconds. Press and play. And then pausing at 33 minutes and 38 seconds. Again, that probably sees that true and accurate representation being extracted.
Yes.
You're not moving towards admission?
I'll offer it as evidence this time. Because exhibit 15.
What's your objection?
He didn't like foundation to authenticate. He can identify it. We're not in 192 layout. He has to be able to authenticate it. This witness didn't even testify as to where the camera is, that's in this video, or basis of knowledge as to how he knew the time that was depicted in the video, actually correct time.
All he testifying to is that he extracted the video.
That he got from the DVR from.
That he personally did.
He got it from, the testimony I heard was that he got it from Detective Shakur.
Did you personally extract the video?
I personally extracted the video.
That's what I thought I heard you say.
From a DVR that was provided to him.
And regardless, who provided it to him, he extracted a video from a DVR.
Correct. That was that.
That's all it can tell us.
Thank you. Nothing.
Cross-examine. Thank you, sir. You missed it.
Thank you. Just to save the court's time, I'll play the entire video. Next. So it's my understanding that I could call my next.
Oh, no, because we're going to give counsel an opportunity to review the phone dump information. Okay, so that's going to necessitate us getting another date. How much time do you need, counsel?
Unfortunately, I'm out next week.
It's not going to be good for your client because your client may not be out next week.
Thursday.
Does that work for you, Mr. Fedora? I'm not sure if it works for the court. Because yes.
It's fine for the people, I staff stay.
1:30?
1:30.
Mr. King?
It works for the defense.
All right. Now let's talk about bond. I want to know why the defendant is not able to get the settlement in this order.
So we actually called, Ms. Montez called the court last week because change my words here. The court, when I raised the issue of Mr. Moore being incarcerated as he waited to tether, the court said they could fashion a way that wouldn't have to happen. So the defense counsel took that to mean that the court would get back to us. Mr. Moore did contact us and asked us, because the court said that something should happen by Friday of that week. He asked us what the status of everything was. I asked Ms. Montez to call the court to see what the circumstances were for fashioning, because I had no idea. And we were told, I think, to draft an order.
I told the defendant to present himself by Friday to have a tether and to take direction from them. Because if they were not able to provide him a tether at that time, then for them to give him a time to get the tether.
I have no reason to think that the court didn't make that note. I'm submitting to this court as an officer of the court. That was not the memory of either Ms. Montez or myself, because we went through this with Mr. Moore countless times. And I made it clear to him that I didn't know what the court was talking about with regards to fashioning some conditions.
What I was trying to do was avoid him sitting in jail waiting on a tether, because sometimes it takes 3 to 4 days. So I was giving him the benefit of the doubt to present himself in person, so he wouldn't have to spend that time in jail waiting on the tether. And I'm being told now that that didn't happen.
I will follow my own sword. I told him that not to. I said that wasn't my understanding of the court's order.
And I told him not to go to the tether office. Why would you tell him that?
Because I wish I had the transcript. I believe that the court told Ms. Montez and myself, my understanding, my memory, my recollection of what happened was that I raised the issue and the court said it was passing something that would result in that, and that you hear from the court Friday.
Yeah, that's what I did, and allowed him to be out and to present himself.
Okay. Well, if I may. Mr. Moore has presented himself for the homicide charge. Ms. Montez took him to DDC herself at 3 o'clock in the morning when we knew this warrant was out. Opposing counsel gave us 24 hours to have him turn himself in, and he did. He knew this charge was coming down because it initially started as a CCW charge, and we were notified and signed a order, a protective order to get the homicide discovery. Mr. Moore was told that night that there was a homicide charge coming. He did not flee.
I've seen this movie before. These are the exact same arguments you made the last time.
I'm just asking to do with the change. I think it's my fault.
Sir, you didn't understand?
Stand up, sir.
You didn't understand what I said when I told you to present yourself by Friday?
Yeah.
I don't know how much clearer I can be.
No, I was thinking that he was gonna refer to him, he was gonna pay me. I ain't never been to this shot. I don't know. Give me just one.
This defendant stands before this court charged with first degree murder premeditated, and he's charged as a habitual default. I can't think of another circumstance or situation where a defendant would be out on bond on any bond. And per the Constitution, these are one of those limited circumstances where I can deny bond, and that's exactly when the court can remand. We can revisit bond again after the preliminary examinations continue.
Given what the court just heard, what every judge before this court has heard, and the facts of this case, this court thinks that this type of case warrants someone being remanded right now.
I have a dead woman. I'm yet to hear all the circumstances surrounding it. I have a dead pregnant woman at that. I don't know what's going on, but we want to err on the side of caution. And that's for the protection of the community.
Can I go to the teller office today? Like, please.
No, sir. I gave you an opportunity. I gave you more than one.
I would just ask the court to put the transcript. I really think the court can do this.
Sure.
Is there a way I can get the transcript today? If I get the transcript today, can we get it? I really think the court can.
I know what I said.
I take
the transcript.
I think I know what you said too. I'm respect. I take copious notes. I'm sitting next to my client. Liberty is something I take seriously.
Not only did I say it, I indicated it in the file as well.
I have no doubt that you wrote it down. That's what I'm saying. I have no doubt in my mind that you wrote it down. Thank you. That is just not the recollection of myself or Ms. Montez. And it's not even something the prosecution asked for.
Is there another exhibit? Is it just one? All right, thank you.
Hey, Chair, did I leave?
Not yet.
Judge King, can I ask, why did you have to turn your back when that video was being played?
Because it wasn't admitted into evidence.
Oh, okay. I learned a lot sitting here. Have a good one.
Thank you, you as well. Yes.
I think they're coming down.
Signed up.
Okay. You caught already?
Yeah, they coming out.
Okay, you got my phone. Okay.
You gonna go down with them?
Yeah.
Okay. You got cuffs?
Council, it's also live stream on YouTube, not on the YouTube video. So you should check.
Okay. Okay, sure.